Wait your lordship on that other day, the standing counsel for the revenue, on the request of the standing counsel revenue lordship adjourned.
I know that.
Right.
that. He asked for recommendation
Yes,
till today.
correct.
After
Much-
bail matter held.
Back.
Button.
Much obliged.
Item 134 and 135, my lord. I have filed memo for withdrawal, my lord. I cannot withdraw. my lord.
134, 135 withdraw.
I may be pardon. Item 47, my lord.
37.
47, matter of compromise. Lordship may take up about now 12 p.m.
What is the offense?
307.
307. You have any the medical evidence and everything is there on the
Everything is.
Yes.
The CD also available. CD available.
Parties are there.
Yes, my lord. All of
You just give your medical evidence and all to Mr. Raghuda and I'll take it up at 2 o'clock.
Item 175.
2 o'clock. 47.
175.
Just Mr. Raghuda, just check it up.
Second item, I think second item, 47.
Second item. Wait.
Get pass kariye.
Let 2 o'clock I'll take it up. I'll just check it up for the which part of the body and what is the offense of weapon used and all. Yes.
Item 175. Item. Paperwork is not ready. Feel free. 175.
Weekly. Let it be. Paper books are not required. Nowadays, you have to take the documents, pen drive and
Take up another date.
let it be there.
178, my lord, hearing matter, colon after vacation hearing matter. Just have received paper.
It may not reach. Why do you worry? It will come after vacation only. Don't worry.
Criminal mission 2016. Order of cognizance is under challenge. Let it be listed.
Give the memo. We are trying to list all the matters.
Pardon, item 153, 3 connected matters, there are lordship, send it to the mediation for mediation. Mediation is failed, lordship. It is listed for admission, final list for that. I will pray, lordship, after vacation. I am for the opposite party, interim order is there, lordship.
Why then mediation fail? I'll decide it.
Let it be lifted after vacation. Also, I am not ready for final hearing. Lordship.
What finally in cognizance order? There must be nothing there.
I am for the, I am
So
for
therefore,
the,
I referred it to mediation.
No,
So it is bound to be dismissed.
I am for the opposite party, lordship.
Bound to be dismissed. Because I gave an opportunity to settle. If you don't settle, then I'll dismiss it. Simple. Let it
Interim
come. Let it come.
interim order is there, lordship. In
So
favor of the
therefore, I
petitioner.
am going to dismiss it. I have sent it to mediation means there must be nothing on the matter. Otherwise, I would have quashed it. Yes.
One CRM matter, your lordship had fixed it to 30th August. And interim order was extended to that date. Now, because it was not listed on 30th August, now trial court is proceeding. Because the interim order was till 30th. That's why your lordship will listed any day this week for extension of interim order.
You have you moved application? You
I filed along.
file a specific application for us.
Lordship. I filed the order copy also with the.
Yes.
My lord, I am from Puri, my
Item number
lord.
167 of the weekly list. Lordship in the previous week has disposed of similar matter arising out of the same TR case. The criminal revision number 584 of 2022. It was listed previously in the item number 154. Your lordship has already heard it and kept it for judgment reserve. Lordship may take it any day.
See, after the miscellaneous matters are over, then I'll try it and take it up. Okay.
That's similar matter. Bless you.
I will be pardoned, your lordship. My case number is listed in the weekly list, my lord. Serial number 180. Many times has been listed, but not this, my lord. Then in supplementary list, would
No, sir, not supplementary. You give me a number including the weekly. Already there.
already here.
See, it's not possible, you know. When I was calling people, you have never come. Today, see the pressure. Can't be. About 130 matters, bail matters and all. How do you expect that I will hear?
Supplementary list
See. Yes, next.
Pardon to mention, Your Lordship. Your Lordship, CRL is 717 of 2017, Your Lordship. This is against the judgment of conviction dated 31/10/2017, Your Lordship. Your Lordship may kindly take up the matter.
Press matter.
Not here, for hearing matter.
Yes.
2017 matter. Vigilance case.
Yes, next.
I am from Puri, my lord.
Yes. Are you mentioning?
Yes, my lord.
Yes. Tell me.
My lord, 12 तारिख रे हमरो गोटे BLAPL थिला 4384 of 2024 कोर्ट से जेतु इन्फॉर्मेंटर लॉयर से appear କରିଗଲେ କୋର୍ଟ କହିଥିଲେ ନେକ୍ସଟ ଡେଟ୍ ରଖିବା ପାଇଁ ତ ମାଇ ଲର୍ଡ ଯେତେବେଳେ ରଖିଦେଲେ ନେକ୍ସଟ ଡେଟ୍ କୁ ସେଟା ଏଥିରେ ପଳେଇ ଆସିଲା ପ୍ରୋଗ୍ରାମରେ ପଳେଇ ଆସିଲା 20th ସେପ୍ଟେମ୍ବର କିନ୍ତୁ ଅର୍ଡର ସିଟ୍ ରେ ପଳେଇ ଆସିଲା 20th ନଭେମ୍ବର ଏଇ ସମସ୍ୟାଟା ହେଇଛି BLA PL ନମ୍ବର 4384 of 2024
Yes, call the serial number. 46? 46. Yes.
My please, your
Yes,
lordship,
sir.
my lord. This is the case, my lord. Petitioner is a lonely, my lord. He produced all
Have you cured the defects and all?
What?
Cure the defects?
already removed, my lord.
Yes.
My lord, may I invite lord's kind attention that I availed a loan from the complainant bank by producing the loan documents. Document that is relating to EC and non-encumbrance certificate. That's so 13 years of non-encumbrance. That means, my lord, my vendor was no any obligation or owes from anything relating to the property. Then bank scrutinized the document and allowed. And that money was straightly bank credited to the account of my vendor. So from the day one, it shows that there is no deception played by the present petitioner. However, when that loan account became classified as NPA, then bank proceeded with the securitization process.
What are the allegations?
Allegation is that it was earlier sold mortgage to another bank. That means I'm a lift-and purchaser.
The incumbency is something different and mortgage is something different.
Yes.
You might have got the incumbency for 13 years, no problem.
Yes.
Title flow is there. But the same incumbency certificate you have utilized for getting loan from two banks.
No. Not my humble submission.
I believe. I have not read it.
Yeah, my lord. Yes, this is I produced the non-income certificate. Bank scrutinized my loan document, found that okay.
And gave the bank loans,
Yes.
no problem. That eventually got NPA.
But the allegation is the day I availed a loan, the same property was placed by my vendor to another bank. That is the case.
That's the reality.
That's the rate.
It was-
By my humble submission, in paragraph 5, page 5, my lordship may can see. I will again. My reading lot. When bank mechanism could not find fault with the document of the loan, it is too difficult for the petitioner to decipher the fault or irregularity. Since the given case, the placed property is placed with another
His
bank by
vendor,
payment.
his vendor appears to have
Yes.
availed loan. He purchased it.
Yes.
And got the incumbency certificate of 13
Yes.
years. If the vendor has done it, I don't know whether the vendor has disclosed this fact to him or not. It has to be seen from the record. If the vendor has done it and he is now defaulted in the what you call the loan, this thing, then how can you make him responsible?
Let him arrest him back to his vendor, my lord. Let him notice court.
Who is the informant?
In bank, ICC bank.
Bank is the-
bank. I have added party.
You implead bank.
Yes.
Uh,
I have implemented bank.
Yes. You have to include the bank, then only we can do something. Right. Legal counsel for the petitioner seeks leave of this court to implead the informant, and vendor is also accused
Vendor is also.
along with you.
Yes. But I have not.
It's
Only
not-
bank is important.
Bank. The
OP number 2.
Opposite party number 2, during the course of the day, issue notice to opposite party number 2, reasonable.
Oh, my lord, the problem.
Yes. Next.
Other proceeding means.
No, further proceeding.
All right.
Further-
I'll.
May please, my lord.
47? Yes.
Yes, my lord.
Yes.
Husband wife dispute. In a DP case, London Court below has granted maintenance without hearing the petition based on only affidavit of the wife, and subsequently NBW has been issued. And I have filed this CRLMC challenging the issuance of NBW as well as the order, my lord.
I'll cause the NBW, go and tell whatever you want. Yes. Show me the NBW order.
Annexer 1, last
One.
one.
Huh?
Annexer
Annexer 1.
Yes, my lord.
The petitioner has assailed the order dated 22/7/2022,
22/7, yes.
passed by SDJM Nagar 22, huh?
Yes, no, 22/7/22, yes. Okay.
7. Whereby the court below has issued NBW against him. Apart from that, besides that, the petitioner is also assailing the said order on the ground that the interim maintenance order has been passed against his client without affording him an opportunity.
Yes,
I am not inclined to entertain this application at this stage. However, liberty is granted to the petitioner to move appropriate application before the trial court. If such application is moved, the same shall be considered on its merit. The NBW issued against the petitioner, however, is the order of NBW issued against the petitioner is set aside, subject to the petitioner appearing before the court on or before 20th of October 2024 and await remedy as per the law. With this observation, petition is disposed of. Next.
Okay.
My lord, 20th of October, that is Sunday, madam. 20th of
On or before 20th Monday or the 21st
October. October 20 Monday.
21st
20 Monday.
On or before 21st October 20.
49.
May I please, your lordship? The petitioner is arbiter, his wife in a PC Act case, my lord. I have given, she is a government servant, he is a assistant teacher. He has given the entire corporation in white annex 2. Let your lordship kindly direct so that he will take instruction regarding annex 2. So that if there is, I am the arbiter.
The investigation is going on.
Yes.
Go and tell all these things to.
Let take instruction so that.
What I'll say is I'll dispose it up for asking the investigating officer to take care of this representation.
This one, and she will cooperate in that. And whatever document she has with him, with her, let him produce before the investigation.
I have already submitted. I have submitted. Your lordship only.
You submit all the documents and the investigating officer will look into it.
And cooperate so that it can be proceeded.
Your lordship only one direction. Your lordship will direct on that. Keep it some other day. So let the report be come.
No, I can't do it because I can't supervise the investigation.
No,
Then I'll have to dismiss it only.
ମୁଁ ଏଟା ଚାହୁଁନି ସେ ଖାଲି report ଆସିଲେ ତ
No. Yeah, we can't sit over the investigation and start monitoring everything. Whatever grievance today, investigation is going on. You have some points to tell.
Yes.
These are PC cases.
Yes.
Your husband is an accused.
Yes.
So
I am the arbiter.
The abator 109 is invoked against.
Yes.
You have some
I am
documents.
also government servant.
You are also government servant. You have some documents.
Yes.
Those documents has to be taken care of by the investigating agency.
Yes.
Generally, what investigation agency does is you give everything, they'll ignore it and file charge.
Yes.
So I'll take care of that situation.
Yes.
I'll simply say that whatever documents are there, once you produce, you being a government advocate,
Yes.
everything has to be taken care of.
Yes. You have to examine because all the documents are.
That's what I'm saying.
The 35 of the evidence have been admitted documents.
That's
It
what
can
I'm
be
saying.
done.
That's what I'm.
And also in the PCR case, onus lies on the accused to prove his innocence.
I'm not conducting a trial. Neither the
That is.
neither the police is going to conduct the trial.
That since it is the admitted document, you lost direct that.
How can I say admitted document or not?
No. Jota course say direct.
No, that's what I'm saying.
No,
Right
that. But
petitioner.
If I agreed, so I will file.
The petitioner is the wife of the principal accused in which is that case?
That is
VGR case.
Yes.
VGR case number
case number 8 of the.
Then counsel for the petitioner submits that the petitioner herself is a government advocate, government.
He's the assistant teacher.
Government employee. Government employee. He submits that under the aid of 107.
No, 12 of the PC Act.
No, under the aid of 107.
No, it has been new act on sir 12 सीधा लगा.
अच्छा नुआ ठीक है. अच्छा नुआ ना. 12. हाँ.
12 of the PC amendment. 12 of the PC Amendment Act 2018.
And under the aid of section 12 of PC
Amendment Act 2018.
The petitioner might be made an accused in the present case. She has certain document to substantiate his case, and he appears and she apprehends that the documents may not be taken into consideration by the investigating agency. Therefore, he has approached this court.
Yes, I have honest and
She has approached this court. She has also annexed a representation at annexed
along
two series, annexed
along
two
with
series,
documents.
along with the documents. In view of the aforementioned, I feel it appropriate to direct the investigating officer to look into the representation made by
And the documents.
petitioner, along with the document attached to the representation.
In accordance with
And,
law.
with
In accordance with the law.
in accordance with the law. With this
And
observation, the
and she will cooperate in
Because, as per your lordship decision, that is the arbiter. To not
No, no,
be
সেটা একটা cover হবে defense
Say all
নଉଛନ୍ତି
this thing, I can't do it. Investigation is going on.
that is
ତାପରେ ଇଏ public servant
Next,
defense
next.
ନଉଛି that will not be
No, no.
applicable and she will cooperate your lordship observes she will
No,
cooperate
no, I am cooperating. That
You
is
will
safe.
give representation means cooperate only. Whatever. Yes. See, in that this stage, unnecessary observation by the court
କିଛି
is
କିଛି ହବା
not
କଥା
called
ନୁହେଁ
for.
କିନ୍ତୁ ଆସୁଛନ୍ତି
Investigation is going on.
Because my
And the
lord,
High Court will keep
because-
on giving
No, no,
observation after observation.
Not that because of that Niharika case that is that
Because-
cannot.
Whatever, actually, at this stage, I should not have
Court has
entered.
no jurisdiction at all
Not,
with all
no
respect my
jurisdiction.
lord.
no, because it is equal.
But I'm striking a balance, and you want this observation, that observation, I'll dismiss it there. I am saying that I don't have jurisdiction.
No, no, no. Most set other.
So
Let
you
it
go
calculate.
happily go with whatever I said, so that something you may get something.
No, it will get another chance for him to
Come.
with a lighter pen.
My lord, one plus one is two. That should not be.
Whatever. IOs are convergent with mathematics.
That calculation same to ରହିବା କଥା.
Yes, next. Yes,
Can
sir.
take up after petition.
Why? In the POXO case, you want quashing.
Yes, yes.
Well, I produced the statement of the victim and
A
kindly.
statement of victim will be tested, sir. Where is that? Where is the statement? What kind of petition is quashing a POXO case? You have only annexed the order by which the cognizance is.
I will file all the documents.
No, I will not enter it.
No PS case also mentioned.
Nothing is there. You
Can
can't
you-
file this, let counsel for the petition seeks to withdraw this petition to file a better petition with particulars and documents,
Miller,
supporting documents. With this liberty, the petition is disposed of. File exhaustive petition if you have a case. All documents, statement, anything, and then you try to, point out
Well,
the case is not made out. A cognizance order is filed and quash it. In a POXO case. FIR copy is also not. See, imagine.
No PS case also mentioned.
How do you
That's
file
why
it? I don't know.
that's
In the
why
first place, I fail to understand how you have accepted this brief. You must be having some document with you while drafting. What are the document you had?
FIR copy.
FIR copy. Why have you not filed that FIR copy?
Legible नसलेलं file आहे ना.
पढ़ले किंती झाले? सर बिना FIR पढ़ के आपण cognizance order challenge कर दो. Cognizance order is only this much. AG attacks the cognizance order saying everything under the earth. Please don't do it so casual work. Huh? Yes.
Written on behalf of Mr. Vishal Lordship. Lordship may urgent it as because the last order Lordship kindly have a glance. 21/5/2024 Lordship. Here the out of love both the petitioner and the victim fled away, and the 16 years victim they gave birth to a child, and there is
All these
settlement.
things are all right, but you have said that you have settled the dispute.
Yes, that a Lordship reflected in the order Lordship. After the
And you said that you have settled the dispute and everything I recorded and pass an interim order. Now nobody is appearing and you ask me for time. Is it not employed to get an interim order?
So, Lordship, possible Mr. Vishal will.
Otherwise, I'll vacate the interim order.
Yes, on
See, you said that you have settled the dispute. I recorded everything. And you said that they will be appearing. On that basis, I passed an interim order.
Yes, Lordship.
Thereafter, neither the parties are appearing, nothing, and you are asking for adjournment every
victim
time.
is
Lordship,
13 years
possible
old,
Mr.
I'll
Vishal
pass
will.
it out.
Victim is 13 years old, Milan.
Yes,
No,
that's
16
what.
years.
What is this going on?
Yes, Lord. Pass over
I'll
after lunch.
dismiss it. I'll tell you.
Yes, yes.
Without going into this, I'll dismiss it.
Yes,
I'm
sir.
passing it over right now.
Yes,
That's it. So, why will you take the responsibility?
Yes,
Let him
yes.
come. Yes.
May I please, Your Worship? And the appellant has been convicted under section 713(2), read with 13(1)
Sentence,
of
sentence,
Act. 2 years, 2 years.
2 years. Be granted and the election of the fine. Admit call for here, Mr. Das name and in cause list also reflect. Yes.
Stay realization fine minor. Stay realization of fine.
Sorry, sir.
Also stay realization of fine.
Oh, that everything I did. Good thing.
Public. So, division and in this case, my lord,
Yes.
FRT has been submitted by the Vigilance Department. And 2099 FR, 2000 FRT submitted. What remains?
Your Lordship may kindly peruse that status report in the Lordship
Yes.
brief notes.
And now what happened? my lord?
Flag A.
এই তো এই সাক্ষী দেওয়া আসুনাহান্তি তো মরিগলেনি লাস্ট কু আমার গোটে উইটনেস কু মানে অ্যাকিউজ উইটনেস কো ট্যাক্ট দ্যাট ইজ देयर অন রেকর্ড মি
Status report.
Flag A.
What is that?
The status of the case.
Then there is all the accused persons, accused nursing Charan Bera. You are nursing Charan Bera.
I am
Asutosh Behera.
Asutosh Behera. In this case, my lord, 16,000 has been misappropriated. That is the allegation. But that amount has not yet been released.
One of the
My lord,
co-accused person is not appearing, therefore it is matter.
No, no.
getting adjourned.
my lord,
File some restriction.
Lordship, I am just submitting. So Lordship may see.
What to do? One of the co-accused person, nursing Bera, is not appearing in the court.
He has appeared, my lord.
That's the report.
My lord, Nursimha Behera has obtained the order from the Hon'Ble High Court, granting 6 months twice time. Your Lordship may see.
That's right,
He
but
is
he is
appearing,
not
my lord.
appearing. That's the report.
My lord,
I should believe my officer.
Your Lordship, I am on behalf of Mr. Asutosh Behera. 16,000 which misappropriation. Lordship may see. That has not yet been released.
That's
ମୋ ନାଁରେ ଯାହା ପାଇଁ allegation କରୁଛନ୍ତି ସେ ପଇସା ବି release ହେଇନି ଆଜ୍ଞା।
you have moved an application for discharge.
Yes, my lord. Your Lordship may see this.
Expedite-
ମୋର ହଉଛି 16,000 ଟଙ୍କା ଯୋଉ Your Lordship may see.
I don't know whether it is part of the charge sheet or not.
Yes, yes,
How-
that-
You have, see,
My lord, once Vigilance has submitted FRT, what remains, my lord? 99 ରେ FIR ହଉଛି 2000 ରେ ସେ FRT ଫାଇଲ କରୁଛନ୍ତି 2013 ରେ କଗ୍ନିଜାନ୍ସ 2024 ରେ
but
ଚାର୍ଜ ହଉଛି।
problem is your co-accused persons are.
ଆରେ my lord, everybody is appearing, my lord. They are government employees. Can't they?
Yes, Mr. Das.
Yes.
What do you say?
Let them take. They are saying that we have given the report
One
that
minute,
to
one-
close the matter, my
One
lord.
minute. Two of the accused persons have died in meanwhile. And there are how many accused now?
Five.
Behera?
5 persons are there. Now
Two-
they are
Two died, remain 5.
No, 9 na.
no.
Total how many accused?
9, 9.
9
Yes.
accused.
Huh.
2 of them had died. And few of the accused persons had came here for filing writ petition and all. And they did not appear. That's perhaps the reason the charge could not be framed. The matter was fixed on
My
January,
charge from 2024.
January of this month.
The charge for him ହେଇଗଲା ପରା।
Hegila,
Charge from ହେଇଗଲାଣି already.
hegila,
My lord,
January.
already framed. Nursimha Behera obtained the 2 times orders. My lord, Lordship may see 6 months time was granted to conclude the evidence. My lord, your Lordship may see this. Thereafter, nothing happened because FIR has been submitted.
What are the
2 ଥର 6 ମାସ ଗଲାଣି।
counts for the Mr. Boli, Mansi, and counts for the petitioner submission.
କିଛି ନାହିଁ ଆଜ୍ଞା ଖାଲି ମିଛରେ ଗଡେଇବା କଥା।
By the order dated 5/4/2023 in writ petition civil number 7657 of 2023 and by the order dated, order dated, order dated 9/10/2023 in the petition 32648 of 2023 have categorically directed the trial court to conclude the trial within
6 months.
6 months.
Already dita ko 6 মাসে গলানি বর্ষে যাই 2 বছর গলানি।
However, the trial has not yet been concluded. This is a case pertaining to an FIR registered in 1999. The trial court has submitted a report on 1/12/2023. At that point in time, charges were also not framed. In view of the aforementioned, the special judge Vigilance Cutter is directed to submit a report regarding the exact status of the trial and the reason for.
In the meantime, the charge has been framed.
Yes.
Charge has been.
2024 charge has
The
been
trial comments after the framing of charge.
One minute.
Let him raise all these points.
Caused.
Why do you raise the point?
Compliance
When you fail to produce the evidence.
of orders as mentioned above. With this observation,
My lord.
release the matter on after 1 week, 2 days.
My lord, may I submit one thing? I'm giving a statement.
I am asking for a fresh report.
Yes, ma'am.
I am asking for a fresh report.
Lordship, my own High Court judgment, may I read your Lordship, may I give him?
I am asking for a report. Let
Yes,
me
yes.
finish the
Oblige,
matter.
oblige.
Why you to waste time?
No, next week, my lord. यही तोड़ो कोर्ट।
Because 2023 a report was sought. Now
Yes.
you have shown me 2 orders.
Yes.
Why it is not complied? I am
Yes,
asking
yes.
him.
Yes, oblige.
And it is attributable to you or what? The court will tell.
Yes.
Let us see.
Next week, my lord.
Yes.
Oblige.
54.
What she permits, my lord, may submit in item 54 before my lord friend submits. This pertains to my lord, his entire controversy, my lord, revolves around because he was let off in the same sets of fact and departmental proceedings. He expect the same
I have
consequence.
kept those matters. 24.
So I'm giving the 3 numbers, my lord, so that all can be.
Yes, 24th, I think. A number they give you look at those. Same issues are.
Same issue.
I'll take together. I'll pass one order.
24.
24th, I think. 24th date.
Today, perhaps. Today it was posted.
No, no.
It
They
It was listed on 20 or 23rd.
No, whatever date is there, just tag with that.
No, it was listed today, my lord, perhaps. 3 matters were listed what time.
So we can bail personal for a disorder. We'll sit it out. We can
Yeah, just check it up and list in one day. Fix it at 3 o'clock. I'll hear all the matters and finish it. Yes. Yes.
But if it will be more than 7 days, my lord, but the proceeding that is in the trial court, it is
You
posted.
move application.
That may be
You application. We'll move application.
for adjournment.
Seeking adjournment owing to the fact that the matter is subjudice. Yes.
Diploma.
55.
Well, 55, we were before your lordships on earlier occasions. My lords, this is a case where we function like a UPI, my lords. My lords, that is, my lords, for example, your lordships have this Petition, and we are the agents for the
Here, my lord, your lordship has directed
You are in
to issue
custody
notice.
since
7/7/23. Everything is documentary in nature.
My lord, your lordship has directed to issue notice to the informant.
Yes, we have already issued
Perhaps
notice.
my
We have
Perhaps my lord, they have also filed requisite. Perhaps they have filed requisite. Though the order was not there to issue the notice, so that was not issued. That is so only
No, there was implead the informant.
implead that
we
was
have
allowed.
implemented the informant as party.
But notice was
And
not
we
issued
also filed requisites.
due to my lord, there is no order to issue notice.
By the order
therefore.
dated 29/8/2024, although the petitioner was permitted to implead the informant as opposite party number 2, however, inadvertently, notice was not directed to be issued to opposite party number 2. Therefore, despite the petitioner filed the requisites, notice could not be issued to opposite party number 2. Hence, utilizing the requisite already filed, issue notice to opposite party number 2, returnable within 1 week, least after 1 week.
And my lord, another thing your lordship may direct that is a survey copy. So police, I also saw that to the informant will be better.
Petitioner is also directed to share a additional copy to the counsel for the state so that in return, the counsel for the state will get the notice served on opposite party number 2 through the IU of the president.
Malams, in that case, can it come up next week, Malams? I'll give an extra copy and I will also send it through speed post.
Reach it up to 1 week. Yes.
Oblige.
My lord, the petitioner is in custody since 25/6/2023, my lord. More than
25/6/23.
my lord.
Yes.
My lord, under section 302/34 of IPC, my lord.
Yes.
And my lord, the allegation is that the
It is there.
role of the petitioner is that only after death of the deceased, only he has taken to the hospital for treatment, my lord.
No, that's not correct.
My lord, kindly see,
120B is there, my lord, against this petitioner, my lord.
My lord, kindly see.
What are the allegations?
Allegations, my lord. The
Statement
deceased
of-
and the all other accused persons, principal accused, my lord, they called the deceased for a painkiller. Thereafter, they taken him to the Mayfair Hotel. After returning, the main principal accused contacted to this petitioner, my lord. Where he is, my lord? The petitioner stated that I am standing near the liquor shop, my lord. Then all the accused persons, including deceased, came there. There was a tussle between themselves. This petitioner, this petitioner along with another accused person, told to the principal accused to fire at the deceased, my lord. Accordingly, they fired the deceased. Instigated. And so also, my lord, this petitioner in order to, my lord, so that nobody will suspect them. For that reason, they taken all the accused person to the hospital and he fled out from the hospital, my lord. And so far, the other accused person is concerned, my lord. That is BLAPL number 81.
Eyewitness, how many were you?
Prior to occurrence, my lord, some person seen the petitioner while standing there, my lord. And other petitions also, my lord, they have
incident.
My lord, there no direct evidence not there, my lord. But one person stated that he went inside the house and had the sound, my lord. He implicated also this petitioner, my lord. He was present very much available, my lord, at the time scene of occurrence, my lord.
What do you say?
But what I beg to submit,
My lord, statement of the
one of the co-accused, my lord, concerned, Santosh Pradhan, his name also in the charge sheet, my lord. And that his prayer for bail, my lord, urgent to 28/10/2024.
Released the present bail application.
Along with the BLAPL number,
BL number
8163/24.
On 28th. Yes, next. 57. Yes.
May I please?
Yes, sir.
Initially 363. Subsequently, my charge sheet submitted under section adding 376(2) and 6 of the POSCO Act.
Yes. Custody?
Custody since, my lord, 28/11.
I think you are expert in 376 POSCO. Every day 2-3 matters you are doing. Yes. Custody.
28/11/2023.
11/2023. Okay, tell me.
What? Here, my lord, 373 notice made sufficient.
Notice sufficient?
No, my lord, sufficient.
Case of elopement, my lord.
Yes, show me 164.
164.
My lord. ମୁଁ ଆମ ଗାଁର ବାପୁ ନା ଘଡେଇ ବୋଲି ଗୋଟିଏ ପିଲାକୁ ଭଲ ପାଉଥିଲି ତାକୁ ମାନେ ପିଟିସନର 27 years and victim 16 years my lord. ତାକୁ ସ୍କୁଲ ଗଲାବେଳେ ଦେଖା କରେ ବାଟରେ ମୁଁ ଯେତେବେଳେ 10th ରେ ପଢୁଥିଲି
Okay, tomorrow.
and he has been released on bail in the appeal lordships.
You get ready with the list of cases.
Yes,
and
Lordship,
whether
yes.
you
Tomorrow.
got bail in all the cases.
Yes, Lordship.
You get ready and come with a written list. Yes. Okay. Yes.
59. 59 my lord, 178 kg ganja my lord, CD
call.
Since 1 year his custody, my lord, I pray my lord start report me since 1 year his custody and without chemical report, my
Let the CD touch. Let the CD.
before
Or shall I dispose it up saying that you will renew the bill?
CD also.
Yes.
60 307. No, here is first.
Yes. 60.
Nobody. Well, prisoner petition, my lord, noting there. Prisoner petition from sub jail. Kotpad. Koraput at flag G.
60 na 60.
60.
Yes.
That noting is there, my lord. Prisoner's petition, my lord.
Yes, somebody is appearing. Yes.
Sir, I have appeared for the petitioner for the first time. And the petitioner.
You are in person or you are appearing?
Yeah, I am appearing from the side of petitioner.
Where is your band? Where is your band, sir? Yes.
61.
61. Yes, Mr. Oda. Today passing over it is very difficult.
Urgent matters. Those matters not appearing, they are urgent matters.
Because today all the matters will be over.
CDG has
July.
matter.
Till July, all the matters of bail matters. In one round, it is over. If they are not coming, then it will go to November. Huh? December, not even November. Pass over.
Pastor.
Will December, we'll adjourn to December. Yes.
62. The council already expired, my lord.
Okay.
The associate might not be.
Okay. Then
Urgent.
61, na?
Right.
61.
Urgent.
Is informed that the council, earlier council appearing for the petitioner has expired. So issue notice to the petitioner. Issue notice to the petitioner.
Associate is also there, my lord.
Let the notice go to petitioner. Why am I? Yes.
62.
62. 62, yes. Diary?
My lord.
Received?
My lord.
Yes.
44 kg, 300 grams ganja.
4 kg?
44 kg.
Release it after 2 weeks. Release after 2 weeks. Non-APS for the petitioner in interest of justice and then after 2 weeks. Yes. 63.
Pass over, your lordship.
Letter no, I'm there, my lord.
Yes.
No. So, change the one.
What do you want?
No, I want to argue the matter.
He says pass over means for whom?
Mr. Manoj Chand.
How he could enter file Vakalatnama without.
You decide between
No, I'm not. Let your lordship, if he has filed any Vakalatnama, neither any from my concern nor any prisoner person.
This is the.
How could he? If he is, I have no problem, my lord. Because certainly he should have either the prisoner person or from the consent taking from me.
Mr. Chand filed.
That is the problem.
Chand is associate filed Vakalatnama.
No, this Vakalatnama filed.
Vakalatnama, neither from consent
It is
nor
better, my lord.
prisoner person, nothing.
Mr. Jafarulal and counsel for the petitioner submits that he has been appearing in the matter. However, fresh Vakalatnama has been filed by Mr. Chand, Manas Kumar Chand, without taking the no objection from him. He had a serious objection to the same. Release the matter after 2 weeks. Yes.
64.
The registry, how the registry can accept it without no objection?
Should not
Generally.
they are giving note to Malat. Or if they are the prisoner petition, then I have no objection. I should not appear.
But no, what is the rule of the High Court?
Also, previous council, that is also mentioned in the GRCO, that previous council's no objection is required. Or I may, on my permission, if I consent, I give consent, anyone can appear.
There must be noting, here not noting there must be noting that the council appearing Mr. Chand without appending the consent from the that will be noting. Noting not there.
Yes. Okay. Next.
64.
Petition is in custody since 7/3/2024.
7/3/24. Okay.
Initially,
Case diary 164 required, my lord. Case diary 164.
Case diary.
Another of
160. Yes. Next. 65.
May I please notes?
Yes.
My lord, petition custody me lord on 16/5/2023 my lord.
15 or 16?
15. No, 16. 16/5/23.
Yes.
My lord. Basing on the implication, my lord, basing on the confessional co-accused statement, my lord, 3% co-accused person similarly, my lord, there, 2 have been released on bail by lordships, my lord. Similarly placed 2 accused persons, my lord.
Check it up, Mr.
I will already check. Last capital here said given, my lord.
What are the rules?
The role man similar role, my lord.
Similar?
In the principal act others, my lord.
Who is the principal agent?
The lordship bail order.
Prasant, my lord, Prasant Prakash and another, my lord. Prasant Sahu, Prakash Sahu and Sibo Naik, my lord. They are the principal real. And so, but this petitioner along with others, my lord. Allegation similar, my lord. They also already dealt with.
If I record the petitioner is accused in so case. prosecution story para 3 ଲେଖା ହେଇଛି para 4 ବି କରିଦେବ confession para 3 କରିଦେବ Land counsel for the petitioner submits that two of the co-accused persons, those who are similarly situated, namely Ramo Raulo and Rahul Panda, have already been granted bail by this court by order dated 2/9/2009. First Rahul Panda and Ramo Ulta by the order dated 8/1/2024 and in 14/8/2024 in BLAPL number 2228 of 2024 and 2/9/2024 in BLAPL 1966 of 2024 respectively. He submits that the case of the present petitioner is similar to that of those co-accused, those who have been granted bail, and therefore he is entitled for parity. Let Mr. Raghunath, Land counsel for the petitioner submits that the principal accused are
Prashant Sahu, Prakash Sahu, and Sibo Naik.
And the role attributed by the prosecution against this accused is similar to that of the accused, those who have already been granted bail. Yes. Custody since?
Custody मतलब 16/5/23.
16/5/23.
से मानी तारा मोर से.
23. Okay.
That matter will honestly
Yes. What happened?
How urgent?
Will you argue? I have urgent it up.
Urgent.
Power. तो लिख दो 61 लिख दो
Notice is not required.
Notice is not required. Least after 1 week. Least after 1 week. Yes. Yes.
May I please? 52 Odisha Excise Act my lord.
Custody?
10/4/2024.
10/4/24.
My lord.
Yes, Mr. Raghunath.
80 quintal some bhang my lord. Co-accused my lord is netted by the owner of the vehicle.
Owner of the vehicle.
Owner of the released bail my lord. They are carrying the ganja. Bhang.
Okay.
Bhang not now my lord though amendment they are not coming under the NDPS Act. Odisha. There is my lord the.
It's no more NDPS.
No. It will come on NDPS my lord.
After amendment.
After amendment. I'm not my lord till it my lord. This is
But at least by the time the offence has taken place.
No bhang.
Co-accused Basudev Lenka has already been granted bail by the order dated bar on Petition in the LAPL number 4936 of 2024. The role attributed to the present petitioner by the prosecution is similar to that.
No, not similar, my lord. But that is your also holding, that is the owner of the vehicle. These petitions, 2 petitions here, my lord, they are carrying.
The said Basudev Lenka was the
owner of the
vehicle. In which the
petitioners,
in which the contraband was seized, and the petitioner is the
there are 2 petitions in this present case.
Petitioners
carrying.
Petitioners driver.
One driver, one helper.
One of the petitioners is the driver, the other one is the occupant, along with the owner of the vehicle.
No, owner not present, my lord.
He was not present.
Subsequently, owner of my lord, not namely referred, subsequently.
Then the roles are different.
The roles different.
Recovered from
these 2 petitions, my lord. But the owner, my lord, the
custody since. What is the sentence prescribed here?
52, my lord.
3 years.
3 years.
3 years. The owners, they will occupy both of them. Yes. Since the maximum sentence prescribed under the section 52 of Excise Act 3 years, petitioners are already on custody since 10/4/2024. Yes.
67. Item 67. It was in the list on 12th or 13th. My lords has kept it to this week. 307 case where the learned court below has reflected that except the wall, there is no scratch mark over the body. CD was not there, my lord says. CD is there. Urgent to 2910, my lord.
But in fact, my friend filed a withdrawal memo.
ଆଉ କଣ କରିବ ଲୋକ 7 ମାସ ରହିଲା ପରେ
Preponed, my lord.
Withdraw, you want to withdraw?
withdraw
Withdraw, yes. Withdraw, yes.
May I please, Your Lordship, kindly recollect. This
Withdraw to renew the bail plea.
My
Renew
lord.
the bail plea
My
with
lord.
trial court if such the petitioner will be on the changing circumstances. If any such application is moved by the petitioner, the same shall be considered within 15 days
My
of the
lord.
date of filing.
My lord.
Your Lordship remembers this case where the parties are distantly related, cousin, brother and sister. My lord, there was a love relationship. That is the case of the victim in the position Your Lordship had perused. One of the witness who says the photos were circulated. That's IT Act was therefore on the last occasion Your Lordship wanted to know whether any nude photo has been seized or not.
Yes.
PW1 says that nude photo means he was sleeping close to the victim. Then PW4 who collected the photos, who had collected the photo has been examined in the meanwhile. With Your Lordship's kind permission, I am filing it. He says no.
Custody smell that I am remanded in this case since February 2024. Note here, last occasion, Lordship has directed the state to obtain instruction as to whether TI Parity has been conducted or not.
No, my lord. Since, my lord, what happened in this case, he has remanded, my lord. He is involved in 6 other cases, including 3 19 cases, my lord, 3 cases, my lord.
So what
And remanded, my lord. The question upon, my lord, identification.
What happened to the case where
That is
initially arrested?
My lord, arrested,
that
my
case
lord.
arrested, I acquitted, my lord.
And other cases also, my lord, he is involved, my lord.
You are supposed to file a affidavit.
Affidavit, my lord. Affidavit stating that
File an
how many
affidavit.
cases and
File affidavit.
Right.
But the whole thing is that, my lord, in this case, there is no matter. Your Lordship, whether all the criminal antecedent, my lord, showing me remanded me, I'm in custody since 2022 and remanded me occurrence of 2022. And can you remind me in the after 2 years in a case where the, my lord, this occurrence took place 2 years back and without any making.
They could not solve this case, so therefore they have to take you with remand.
Whether, my lord, whole thing, my lord, whether only criminal antecedent showing me criminal, it is the ground to, my lord, not to consider, my lord.
He has to
There
file
is no
compliance
other
affidavit, my
material.
lord, stating
No,
that
At least the court should entitled to know what are the cases against you.
My lord,
File an affidavit.
that is mentioned. I will, my
Mr.
lord.
Jafarullah, learned counsel for the petitioner, submits that he would be filing and detailed affidavit, an affidavit detailing the particulars of the cases the present petitioner is involved and status of those cases.
I have a copy, my lord, your Lordship.
No, you give a chart and reproduce that and
Short date, that is.
yes, 1 week after. Yes. Yes.
Before, my lord, before vacation, my lord, otherwise.
Yes, 70. 70. 70. Yes, sir.
Same case, my lord. 376.
He is an expert now.
ସେ ଜିନିଷ ନୁହଁ ଆଜ୍ଞା ଏଇଟା ଯେତେବେଳେ ସବୁ ସିରିଏଲି ଆସିଥିଲା ଯୋଉଗୁଡାକ ହବା କଥା ବେଲ୍ ସେଗୁଡା ସବୁ ଆଜ୍ଞା ହେଇକି ଚାଲିଗଲା 302 376 ପୋସ୍କୋ ଆଉ 304B 302 ହଜବେଣ୍ଡ ଯୋଉଗୁଡା ଆଜ୍ଞା ରହିଗଲା ରେସିଡ୍ୟୁ ହେଇକି ଛାଣି ହେଇକିରି ସେଗୁଡା ହଜବେଣ୍ଡଙ୍କ ପାଖକୁ ଆସୁଛି ଆଉ ମୁଁ ତାଥରେ କଣ କରିବି ଯୋଉଗୁଡାକ ରହିଯାଇଛି
All cases are
ଆଉ କଣ ପାଇଁ
on my head.
ହଁ କଣ ପାଇଁ ଏଇ କେସରେ 164 ନ ଆସିଲେ ହେଇପାରିବନି
That means you are saying that you are not entitled to bail. Still, I am granting bail. Yes, tell me.
ସେତେବେଳେ 164 କିଛି ନଥିଲା ଫ୍ରେଶ ଆସିଥିଲା ସେ 164 ରେ କହୁଛି ଯେ custody since my lord arrested on 6/2/2024
6/2/24
my lord
okay
and the victim stated in your 164 ଗତ 23 ତାରିଖ ରାତିରେ ସନ୍ଧ୍ୟା 7ଟା ବେଳକୁ
age of the victim
age is
15 years
15 plus
and
ଗତ 23 ତାରିଖ ରାତିରେ ସନ୍ଧ୍ୟା ବେଳକୁ ଲିଟୁ ସୋରେନ ଆମ ଘରକୁ ଆସି ତାଙ୍କ ସହିତ ଦୋକାନକୁ ନେଲେ ସେଠାରୁ ଆସି ତାଙ୍କ ସହିତ ଯିବା ପାଇଁ କହିଲେ ମୁଁ ମନା କଲି ଯିବି ନାହିଁ ବୋଲି କହିଲାରୁ ମତେ
notice service made
sir
Here, initially case was registered under section 363 of IPC. Subsequently, charge sheet submitted under section 363, 366, 376 AB 109.
What is the age of the girl?
The victim is 11 years.
12. 12.
Petitioner is 28 years.
One thing, you can see the rejection.
How many lead applications?
My lord, there are three bail applications. And three FAI.
1, 2, 3.
Three. Five cases, but three FAIs. And the past one also DLPL number 579.
Last occasion, we also directed that after the case insisted against the IIC, whether all these cases has been initiated or not. But actually, my report to their lordship, from 2014 till 2044, all the 18 cases are there. After the case against the IIC, only 3 cases are there. Yeah, I am submitting that one. I giving the chart. Once this case was initiated 2021, 2022, when it came, now in 2024, all these cases have been initiated. That's it from the very beginning.
How many cases prior to the incident? Prior to
Only 3 cases after this incident. Otherwise, all these cases are initiated after the 1cc cases filed before the GMMC in different forums.
Prior to
total how many cases?
total my lord, eight cases. No, so 7 cases. Sorry, 7 cases after I filed the complaint case, my lord, against the IAC.
But this report is something different.
That is my lord. I have filed a chart, my lord, given a chart before your lordship.
Where is that chart?
That dead chart would be again.
Conquest 99
And you compare this. Give a copy.
Oh,
I'll take it up.
I'll give a copy. Yes.
Give a copy.
Yes, sir.
The Commissioner, Counsel for the State has submitted a report obtained from IIC Soro PS. Copy of the same is supplied to Mr. Tripathi for the purpose of reconciling the facts with the facts of found mentioned the subject date chart filed by him. Release the matter up to 1 year.
My lord, Friday, my lord.
Huh?
Friday, I pray.
Huh?
I pray for Friday.
Oh, Friday. Compare it. Yes. Compare it, huh? Just see.
My lord,
What are the
your lordship fixed to 27.
Yes.
My lord, 75.
75, yes.
My lord, so far the agent petition are concerned.
And give a detail in all the cases you are on bail or not. All the cases you are.
41 case ସବୁଥିରେ ମୁଁ ବେଲ ଲାଗିଲା ଏଟା ମୁଁ ଆଇଏସି ନାରେ ଲେଖିଲା ପରେ
And
7ଟା କେସ୍ ମୋ ନାଁ
but he said 3 cases. In these 3
Yes,
cases,
yes.
you are
There is a-
then you are in custody in 3
Yes.
cases only.
Yes.
ଆଉ ବେଲ ଯାଇ ସାରିଲେଣି ସେଠି ତଳକୁଟ
Bail granted.
ବେଲ ଗ୍ରାଣ୍ଟେଡ ଆଉ ଦିଟା ସାନେ ରିମାଣ୍ଡ ଦେଖେଇ ନାହାନ୍ତି
The moment you get the bail, they'll remand in that those matters. Why are you not remanding them? If he is in the custody, you know that there is a case against him.
Yes.
Why are you not taking in remand?
Not one. Lordship, I will next date I will all these things I will.
No, see, I'll tell you one thing. Accused is in your custody. You know he has 7 cases. What stops you to take him in remand in other cases? You will wait. He'll get the moment he'll get the bail. You'll take remand in one matter.
These questions now he raised.
He will try and
without knowing all these things. I will give this one. Only on next date I will.
I'll tell you, if you have not taken
Yes.
remand
Yes.
in the cases you know that it is registered against him,
Yes.
then I will grant bail irrespective of his application.
Yes.
This is no way allowed.
Yes, sir.
You know somebody is in custody. You know the number of cases. You take remand in all the cases.
Obviously.
He will try and struggle get a bail in one case. Thereafter again remand.
No,
This
yes.
is not acceptable. If you don't have knowledge, subsequently you get the knowledge, I can understand.
Only that same thing I will try to do.
You
Yes.
yourself says that there are cases, and he says in 2 cases you have not taken remand. By the next date, you take remand in
Yes.
those cases so that he
Yes.
can get bail or he will not get bail. That is the
cases
problem.
are from the same police station so question of
No, not same police station. Different police station. Only Lordship, I have given the other police stations case. Yes.
But then you know,
Yes.
even if it is other police station, then you know the cases. You take it in remand in all the cases.
Yes, sir.
Put it on immediately Friday. He may not get that information. Let it be immediately after Friday. first working day. On third. And come with this thing. And if you have not taken remand, you tell the IO to take remand in all the cases.
Yes, sir.
And tell me that you have taken remand in all the cases.
If you lordships pass verbally, so as you know, some
No, but that's good for you. At least you will try to understand. I will give grant bail in this case, then you will be taken in remand in another case. Better than all the cases, the remand should be taken so that you can get the bail and come out. That's the whole idea. That's the whole idea. Yes. So that I can grant bail in, you can come out. Otherwise, you'll never come out. Yes.
75, my lord.
Yes, sir.
302. My lord, the petition number 1 is a lady and is custody since 22/11/2023.
22/11/2023.
Petition number 2 is...
1 is a lady.
My lord.
Petition number 1 is lady.
Lady. 2 is her brother is in custody in 23/11/2023.
What about the lady? She is also.
My lord.
What about the lady? She is in custody since 22/11. Okay.
Petition number 2 is on 23.
20. My lord, absolutely there is no materials against this present petition.
There's brother and sister. Petition number 1 and 2. Petition number 1 name is in the affair. Allegation is made there that the deceased has some illicit relationship with the petition number 2. When the dead body petition number 1. And when the dead body was found, it was found in an abandoned well, wrapped with a jory bag. And my lord, PM report is obviously it is drowning. And diatom test also found positive. And my lord, these 2 brothers of the petition number 1 and her father, they were arrested. And on the same day, petition number 1 also arrested. Next day, petition number 2 was arrested. And my lord, the only...
And what about the bail application of all the other father and other brother?
They are in custody. They have not moved.
And my lord, leading to discovery that wooden bolla and motorcycle of the deceased, it was recovered from the co-accused Kanha, leading to discovery. Another brother of the petition number 1.
But I'm just examining about Sunita.
And Sunita,
what is the role of Sunita?
Sunita role is he only make a phone call to the deceased to come to their school.
Because they were in relationship.
He has a relationship with the planning, my lord, because at the school, 3 brothers and father, they were present when the Sunita called to the deceased by phone call. They were assaulted the deceased, and they have they have warped in a jory bag and also thrown to the well. Therefore, it was drowning. The PM report is drowning. One role, petition number 1 role is only she has made phone call, but other petition number 2 and others, they have assaulted.
My lord, so far petition
anything has come on record that they were in relationship. If they were in relationship, there is no occasion for her to participate in this gruesome murder.
They have made a plan because though he was a relationship with the petition number 1, the brother and father, they have made a plan to kill the petition number 1, to kill the... No, my lord, that matter may not be urgent, my lord. Just assaulted.
What happened? Why?
My lord, because my lord, he has taken the advantage of that assignment, my lord. Petitioner, he has filed 1 case, which is before your lordship. Another case he also filed, which is before your lordship, Justice A.K. Mohapatra. In both the cases, CD was called for. If this court will grant bail, that case will be withdrawn. Or if your lordship will reject it, that case
Why
will...
2 cases are filed?
No, my lord, this is the order, my lord. Your lordship may reject this with its cost, my lord. Why he has that the present petitioner, the role of the present petitioner, my lord, kindness.
Why this?
And that case,
these are sharp practices.
And also not giving certificate in that case. And due to assignment in both the cases,
keep it up. Pass over. I'll not only dismiss with cost. Yes. 78.
May I please, your lordship? May I please, your lordship?
Yes.
Lordship, I am through receipt from Sambalpur, lordship.
Okay. Mr. Mishra, yes.
Offenses, lordship, here the offenses are 21C, 29 of NDPS, and lordship.
What is the recovery?
There is recovery of cough syrups, lordship.
My lord,
cough syrup.
You may take it 1 by 1 because there is
How many
19
cases?
numbers of cases, my lord.
19 cases.
My lord, 19 number of cases.
Mm-hmm.
My lordship may take up one by
One by one.
So accused is same.
Same.
No, no, accused is not
Number of
same.
accused, sir.
FIR is same.
FIR is same.
All these accused are.
My lord, actually,
How many accused in this FIR?
As per the FIR, Lordship, near about 26 accused, sir.
Acha. These all the accused are co-accused in same FIR.
my lord, what
Same
happened?
FIR. And some, Lordship, 27 accused and some of
What
the
is
accused
the
already.
What
recovery?
happened, my lord? From the truck, 55, 5500, 5,520 bottles of cough syrup was seized from a truck. And from the spot, 7 persons were apprehended from the spot. And one truck, Hyundai car, Maruti car, and Hero motorcycle. It was also seized from the spot. Other persons are fled away from the spot. And my lord, if we calculate that the codeine phosphate, that is, my lord, as per the calculation, 5 ml, it was 0.1 gram is there. And 5,500, 5,500, 2,000 ml, my lord, it is 1 kg, 104 gram. That is above commercial quantity.
Clear.
And my lord, in the first case, my lord, he was not apprehended from the spot. He was fled away.
You give a chart then. Those who are not apprehended,
My lord,
conscious position is not there. I'll grant.
my lord,
conscious
I'm
position
giving
there,
one
I'll
by
reject.
one. I'm giving
Lordship,
first
Lordship,
case-
may I permit, Lordship?
1 minute. He's assisting. Wait.
Sir.
Oh, the 9 cases. Now you give in right.
19 cases. 19 cases, I have a chart, my lord.
Chart.
In
You
first
give me
case,
chart.
my lord, there is 3
You tell
numbers.
me who are the conscious position. I'll reject.
In the meantime, your lordship
the-
granted anticipatory bail. Some of the co-accused persons granted anticipatory.
My lord, first case, he was not apprehended in the case, apprehended from the spot, but he has 3 numbers of antecedent. It's first.
Okay.
My lord, second, my lord, he was not apprehended.
Can you give me? Right. You have one copy. Huh?
Then my lord, second, 11 numbers of antecedent. And
No,
some,
do you have a copy?
no, my lord, move ahead, there is.
I'll
Note करतील खाली.
take it up, passing it over. Get a copy so that it will be easier. 1 minute. Yes. We can dispose of a couple of matters and couple of matters. I'll remand it back.
Anticipatory order
Yes. Just see, give the anticipatory bail application orders to him also.
Yes.
He'll just compare if the role of any accused is similar to the role of the persons who has
My
granted
lord,
bail.
if your lordship will grant bail those who are not apprehended from spot, but they have some antecedent, which condition lordship may.
So just check it up. That
Yeah.
also will take into
कोडिन भी 1 kg ଟିକେ ଅଧିକା କମର୍ସିଆଲ କ୍ୱାଣ୍ଟିଟି
whatever quantity of cough syrup.
ନାଇଁ ତାଙ୍କର କିଲେ ଯାଏ ରହୁଛି ରହୁଛି
Lordship, may I permit, Lordship?
ଆଉ
Pass it
Lordship,
to. Yes.
Lordship, may I permit, Lordship?
Yes.
Lordship, may I permit? I just want to submit something, Lordship.
I am passing it over, sir. I'll take it up at 2 o'clock. Yes.
79, my lords. Custody since 29/5/24, my lords.
29?
5/24.
24. Okay.
Sections are under 363, 366, 376, 2N, my lords.
Yes.
And read with section 6 of POCSO, my lords.
Yes.
Allegation, my lords, his father, victims. One of the occupant. That's a vehicle.
Yes. CD is there?
My lord, not CD is not available because that is the Bharatpur PS case. The IIC has already been suspended.
I have already handed over the charge sheet and all.
No, but I'll grant bail less than 100 kilo, but without CD I can't.
No, I have already handed over the.
Right. CD called for, list it immediately after 1 week. Huh? Get the CD.
Right.
On the record, it should be there that CD is called for. Yes.
My lord, yesterday I have a contact, but
Huh?
Joe was
No,
suspended, one IIC is in charge. So
Now they're busy there.
that
They will file the anti-judicial bill. Because case has been issued. 101 is the same. 101 is the city actually. 101 টা
101 রে সেম কর দিও পরে দুইটা সাথে লগাই দেব
next week, my lord.
নেক্সট উইক Yes. 82.
मैं plus में custody since 19th July 2023, my lord. Charge sheet in the meantime submitted. Page 32 is the
Custody
19th July 2024.
93.
19/7/23.
Okay.
And 164 I have annexed at page 32, annexed at 4.
Yes.
Consensual relation.
21. Yes.
Yes, madam.
Girl is
girl 17
is
Age
sorry.
both are 35 years.
Both
And
35.
But my lord,
She is
this
a
is
married lady.
Custody?
She is a married lady.
This is exploitation, man.
Another 24, okay.
Let's say 25.20 gram of brown sugar.
25 gram of brown sugar. And he has similar antecedent, Lordship, with
I
condition.
will not say that. Then I will have to reject it. At least let him do his job. Why not? Nothing further. 25 gram, custody from 13/5/2024, and the verification of antecedent. Yes, granted weight.
Let's see one similar antecedent. One similar antecedent. Let's.
I will not say anything about it. No. I am ignorant about that.
Public.
Yes.
It's not Lordship 3763. Notice is coming.
Yes.
Notice is.
Yes. Notice.
3763.
376. The notice.
Notice sufficient. I am appearing for it.
You are appearing for. Achha.
My name is reflected.
Who is there?
Mr. Roth, my right.
After person to the notice dated notice issued by this court on 1/7/2024. So entered evidence for the opposite party number 2. Non-appears for the petitioner. Leave the matter after 3 weeks. Yes.
376(2) and 6 POCSO. Custody since 15/4/24.
15/4/24.
Yes. Case of consent, my lord. 164 statement does not disclose any of
30 years.
17 years, my lord. No.
37 years. Double.
164 kitchen. Nothing.
Same things we have gone by my own.
What is this man? He's 30 years. What is he doing? He's married. Yes.
My letter informant to the wife of the deceased. Well,
Charge sheet filed.
Charge sheet was filed and
when
4 witnesses have been examined so far.
Charge sheet filed on 29/6/22.
22.
Yes.
Well, informant is the
4
wife.
witnesses examined.
4 witnesses have been examined, and material against me that informant is not an eyewitness to the occurrence. She stated that there is a marriage arrangement was there for their daughter. Their marriage arrangement
When
there.
those evidences were recorded?
Evidences.
Date.
Let eyewitness may be examined, Lordship. 3 eyewitnesses are there. They have seen the last scene.
Last scene केवल eyewitness के नांती केस को चुनते थे किसी जन गांव लोगों को देखले जितना
When it was recorded? Just give.
मतलब last recorded मतलब 2023 रही थी ना तापर तो 15/7/2023 रही. This is the fourth witness.
तापर ही.
पर्यंत कोरोना 2024 सरिया ऊपर है.
Direction was given to early.
The eyewitness के नांती. Only last scene.
Material witnesses are not examined.
Material witnesses मतलब material witnesses means मतलब the last scene. Last scene में से कोचन ता घरू बाहर circumstance. Only circumstances to implicate me. Only this is the circumstance. The घरू बाहर
27 himself
how many witnesses?
He has admitted.
How many witnesses? The material witness according to you?
4 is there.
Huh?
4 is there.
4
Yes.
material witness. And they were not material witness.
No.
Huh?
No, but I have not seen.
No, they are not the material witness.
I have not seen that.
अच्छी जाने दीटा seizure witness अच्छे material witness के नाम से तेरे.
Material witness examined 6 months.
Material witness मतलब this is the only circumstances. मतलब I am already in custody for 2 years, more than 2 years.
I know. Easily 6 months I am giving. Either whichever is earlier. Whichever is earlier. Huh? 6 months material witness to be examined. Whichever is earlier. Really? Yes. 90.
CD is required.
392, my lord. Petition.
Call for CD. Yes. Next.
That is the remand case, my lord. In main case, my lord, he is arrested, my lord, in conduct case.
Let the CD come. 1 week after. Yes.
Next week, my lord.
91. Yes. Yes.
The petition is in custody since 38/2023. And the alleged offence are under section 376(2)(f), 376(3) and 6 of POCSO.
Yes. 373 there.
Again?
Notice.
Notice H again? Notice H. I'll take it. I've made them parties also. I've given the amended cost title. I've taken notice to register post.
You have not filed process.
Yeah, I filed your lordships.
That's what the report.
I filed it also on the same day. But because the cost title was not there, they have not taken into account.
Or maybe whatever technical problem is there.
I'll do
after 1 week. After 1 week.
I'll do it. I'll take this steps.
Yes. Notice on the victim, the informant, could not be served due to some technical issues. Mrs. Naidu undertakes to cure the defects and notice be issued to the opposite party. And a advance copy of the petition shall also be served.
Twice.
And serve to the counsel for the state, who in return will communicate it to the IO for serving the victim oblique informant for the next data hearing.
That was there earlier also, Your Lordship.
But you do it once.
I'll
that,
do it, Your Lordship.
no, you don't leave the chance. Yes.
92.
Lord, petitioners have in custody since 25/1/2024. Lordship 1/2024.
Yes.
92 and 93 are arising out of one affair, Your Lordship. 92 is the man accused who have assaulted, who has assaulted to the deceased, and others are there, Your Lordship. Here the deceased himself responsible for his death, Your Lordship. He along with his friend went to the picnic.
He is the aggressor.
Aggressor, Your Lordship. And
what is? Let us see first. Abhimanyu. Abhimanyu. CD is there?
Yes, sir.
Just see. Tell me about Abhimanyu. Abhimanyu is in custody since 25/1/2024.
Yes.
Yes. Tell me his role.
So TI period was made.
Huh?
TI period was made.
in this case, eyewitnesses are there, Your Lordship.
Yes. What is the role assigned to him, Abhimanyu? You tell me at least.
My Lord, I'm placing the statement of the Abhimanyu, Your Lordship.
You tell me orally.
My Lord,
I am not executing. I just want to know the little idea. So I
in this
grant bail or
my Lord, in this case, Your Lordship, the deceased along with his friend had gone for picnic. They are doing picnic, Your Lordship, and there are disturbance at that spot, Your Lordship. And in that disturbance, the deceased either played key role, Your Lordship. At that time, two persons came to the spot. Name of those two persons are Suresh Pradhan and Pankaj Dharua. These two persons restrained the deceased, not create any disturbance at this spot. Other persons are also doing picnic here, my Lord. But the deceased fled away these two persons by abusing them, Your Lordship.
yes.
Thereafter, 7 to 8 persons came to there. Out of 7 to 8 persons, 2 persons were holding two lathi, Your Lordship. One person's Abhimanyu, the present petitioner, assaulted to the deceased on the head. Therefore, the deceased fall on the stone, Your Lordship. Sustained twice head injury, my Lord. And another person's assaulted to.
Then you have assaulted. Abhimanyu
Yes,
assaulted.
Abhimanyu assaulted.
What about the other guy? 92 na item?
93, next statement.
93.
My Lord.
93. What about Minakatan Naik?
Minakatan, the others are present there with the.
Then according to you, Abhimanyu has given the blow.
My
The
Lord.
other people were there.
My Lord.
When the fight broke out between
My Lord. Another PM
What is-
report is also saying that due to the head
it's a
injury,
case of single blow in the head
single blow
by a lathi.
by a
He fell
lathi.
down and he got stuck in a
My
stool,
Lord.
whatever.
My Lord.
That's what the case.
That is the
Yes.
case, Your
What do you
Lordship.
say?
Yes, Lordship, that is
You
the-
tell me Minakatan. Forget about Abhimanyu because he has given the blow.
Lordship, that ପରେ ଜାଣିଲି after the TI period that ଇଲାକାରେ କାରବାର କରିଥିଲେ ସେମାନେ ସୁରଜକାନ୍ତ ଭୋଇ ଇଲାକା ହେଲା ଆଉ ଧର୍ମେନ୍ଦ୍ର କେ ବୁର୍ଲା କେ ଜାଣିବାରେ ପାଇଲି ମୁଦଲା ଚିହ୍ନିଲି ଯେ ମୁଦଲା ନାମ ହେଲା ମୀନକେତନ ନାୟକ ଲକ୍ଷ୍ୟପତି ଧାରୁଆ ଅଭିମନ୍ୟୁ ବାଲାମ ଲଳିତ ପ୍ରଧାନ
No, TI period they were identified.
All the 8 persons were
One
identified.
minute, 1 minute. They were identified. They were there. He is admitting it.
Yes.
TI period is not necessary now. Now, what is the role attributed to them?
that part at the time they did not know only they have said in his one statement that ଜଣେ ବାଡେଇଲା ଆଉ ଜଣେ ତାକୁ ଧରି ପକେଇଲା
Thereafter, whatever you said, what is the
That-
role
that I am
assigned?
ready.
Because I am
That
examining 302.
yes
In 302, what is the role assigned to them?
ଆମେ ଏଇ ଗଲେ for that only I am saying 7-8 ଜଣ ହଠାତ୍ କିଛି ସମୟ ପରେ ଆମ ପାଖକୁ ଦୌଡ଼ି ଆସିଲେ ତାଙ୍କ ଭିତରୁ ଜଣେ କାଠ ଫଳିଆ ଧରିଥିଲା ଆଉ ଜଣେ ବାଡି ବଗିରେ ଲମ୍ବା କାଠ ଫଳିଆ ଗୋଟେ ଧରିଥିଲା ସେମାନେ ପ୍ରଥମେ ଧର୍ମେନ୍ଦ୍ର ସାହୁକେ ମୁଡେ କାଠ ଫଳିଆରେ ପିଟିଲେ ଯେନ୍ତା ସେ ତଳେ ମୁଡେ କଚେକେଇ କରି ପଡ଼ିଗଲା ତାପରେ ସୂର୍ଯ୍ୟକାନ୍ତ ଭୋଇ ତାହାକେ ଉଠାଇ ଯିବାକୁ ସେମାନେ ତାକୁ ମଧ୍ୟ ତାର ମୁଣ୍ଡକେ କାଠ ଫଳିଆରେ ମାଡ଼ ମାରିଥିଲେ ଫଳରେ ତାର ମୁଣ୍ଡ ଫାଟି ରକ୍ତ ବାହାରିଥିଲା ତାପରେ ଅନ୍ୟମାନେ ମଧ୍ୟ for that only I am saying
ମାନେ 307 କାର against
ତାପରେ ଅନ୍ୟମାନେ ମଧ୍ୟ
no before
ବିଧା
before that
before that
ସୂର୍ଯ୍ୟକାନ୍ତ
ତାପରେ ସୂର୍ଯ୍ୟକାନ୍ତ ଭୋଇ means that side ସୂର୍ଯ୍ୟକାନ୍ତ ଭୋଇ ତାହାକେ ଉଠାଇ ଯିବାକୁ ସେମାନେ ତାକୁ ମଧ୍ୟ ତାର ମୁଣ୍ଡରେ କାଠ ଫାଳିଆରେ ମାଡ଼ ମାରିଥିଲେ ଫଳରେ ତା ମୁଣ୍ଡ ଫାଟି ରକ୍ତ ବାହାରି ଯାଇଥିଲା ଇଞ୍ଜୁରି ଆଦର ପାର୍ଟ
that's 307
ହଁ ତାପରେ ଅନ୍ୟମାନେ ମଧ୍ୟ ବିଧା ଲାତ ଆଉ
you read the evidence of ସୂର୍ଯ୍ୟକାନ୍ତ
My lord, I have. Yes, lord. ମୋର ନାମ ସୂର୍ଯ୍ୟକାନ୍ତ ଭୋଇ ବୟସ 24 ବର୍ଷ ପିତା ହରିହର
read the relevant part
My lord, yes, lordship. ସେନେ ଆମର ପାଖରେ ଗସ୍ତିଡି ଗାଁର ଲୋକମାନେ ମଧ୍ୟ ଭୋଜି କରୁଥିଲେ ଆମର ରଡା କିଲ୍ଲା ଦେଖିକରି ସେମାନେ 2-3 ଲୋକ ସମଝାଇବା ଲାଗି ଆସିଥିଲେ ଆମର ତାଙ୍କ ସହିତ ଗାଲି ଝଗଡା ହୋଇଗଲା ତାପରେ ଆମକୁ ସେମାନେ ଆମରନୁ ଭାଗି ଗଲେ ଓ 7-8 ଜଣ ଲୋକ ହଠାତ୍ କିଛି ସମୟ ପରେ ଆମ ପାଖକୁ ଦୌଡ଼ି ଆସିଲେ ତାଙ୍କ ଭିତରୁ ଜଣେ କାଠ ଫାଲିଆ ଧରିଥିଲା ଓ ଆଉ ଜଣେ ବାଗି ଲମ୍ବା କାଠ ଫାଲିଆ ଗୋଟେ ଧରିଥିଲା ସେମାନେ ପ୍ରଥମେ ଧର୍ମେନ୍ଦ୍ର ସାହୁକେ ମୁଣ୍ଡେ କାଠ ଫାଲିଆରେ ପିଟିଲେ ଯେନ୍ତା ସେ ତଲେ ମୁଣ୍ଡ କଚାଡ଼ି ହେଇ କରି ପଡ଼ିଗଲା ତାପରେ ମୁଁ ତାହାକେ ଉଠାଇ ଯିବାରୁ ସେମାନେ ମତେ ମଧ୍ୟ ମୋର ମୁଣ୍ଡରେ କାଠ ଫାଲିଆରେ ମାଡ଼ ମାରିଥିଲେ ଫଳରେ ମୋର ମୁଣ୍ଡ ଫାଟି ରକ୍ତ ବାହାରି ଯାଇଥିଲା ତାର ପରେ ଅନ୍ୟମାନେ ମଧ୍ୟ ବିଧା ଲାତ ଆଉ ମୁଠକାଥି ମାଡ଼ ଦେଲେ ବିକାଶ ଛଡ଼େଇ ଗଲା କି ତାହାକି ସେମାନେ ଟେକି କରି ଫିକି ଦେଲେ ଧର୍ମେନ୍ଦ୍ର ବେହୋସ ହୋଇ ପଡ଼ି
when does she say that who has given blow to whom
My lord, subsequently on evidence come your lordship
subsequent no eyewitness is this he is the
he the star
he is the injured witness let him be examined right down petitioner is accused on so and so allegation against the petitioner
my lord your lordship in this case the evidence has been clear your lordship the 27 evidence it is there
Suryakant
my lord
evidence should be recorded
my lord
injured witness
my lord he
302
my lord he specifically stated name of 2 persons those 2 persons 1 person assaulted
I didn't find that
my lord
you read it over I didn't find that
I have mentioned your lord's my bail petition
evidence show me from Suryakant evidence
my lord
he is the vital witness to
my lord he stated name of 2 persons your lord my lord those 2 persons were later on come your lord because in this case not the Suryakant the person the injured eyewitness but other persons are also there they are also eyewitness your lordship they have mentioned the name of those 2 persons who have assaulted your lordship
you are not focusing there see it is a free fight
this
between 2 groups
my lord
and 1 person died 1 person injured
my lord
for 302 and 307
yes lordship
and now the vital witness is the person who was there received injury that is 307
my lord
that is Suryakant
my lord
from the Suryakant account you told evidence you show me that who has done what he says that everybody has done it unless he is examined how will I know it
my lord
why don't you understand this much
your lordship kindly see the PM report
I will not read any other evidence except Suryakant
death is due to the head injury your lordship and head injury caused by 2 persons your lordship only 2 persons assaulted 1 person assaulted to the deceased and another person assaulted to the injured person your lordship
you are saying
my lord entire case is saying your lordship I am not saying
I am talking about Suryakant so tell me the Suryakant
my lord Suryakant
is taking name
he is not taking name of subsequently other eyewitnesses stated the name of those 2 persons assaulted to the injured and the accused your lordship
how many eyewitnesses
lordship I am reading that one then ଆସି ଛତିଶଗଡ଼ର ଅନ୍ୟ ପିଲାମାନଙ୍କୁ ନିର୍ଘାତ ପିଟିବାରୁ ସେହି ଛତିଶଗଡ଼ର ପିଲାର ଦେହ ମୁଣ୍ଡରେ କାଠ ଫାଳିଆରେ ପାହାର ବାଜିବାରୁ ସେ ତଳେ ପଡ଼ି ଅଚେତ ହୋଇଗଲା that previously he has read that one ତାଙ୍କ ଗ୍ରାମର ସୁକେଶ ପ୍ରଧାନ ଲଳିତ ପ୍ରଧାନ ସୁକମଣି ବାଲାମ ସୁକାଶ ମହାକୁର ମିନକତ ନାୟକ I am reading this one ମିନକତ ନାୟକ ପୃଥ୍ୱୀପତି ଧାରୁଆ which one petitioner there ତାଙ୍କ ପୁଅ ପଙ୍କଧର ମଧ୍ୟ ଯାଇ ସେହି ପିଲାମାନଙ୍କୁ ବିଧା ଗୋଇଠା ମାରିଥିଲେ ତାପରେ ସେ ବ୍ୟବହାର କରିଥିବା କାଠ ଫାଳିଆକୁ ସେହି ବଣ ଭୋଜି କରିଥିବା ସ୍ଥାନରେ
my lord ବିଧା ଗୋଇଠା ମାରିଥିଲେ your lordship
that ବୁଦାମୂଳେ ଲୁଚିଥିଲେ that body there that also has
your lordship 27 evidence is there your lordship and the weapon of offense has been seized from the Lakshapati
from the evidence form
my lord he the deceased he himself he the responsible your lordship and the man assailants the prosecution distinguished the man assailant those are 2 assailants who were assaulted
let me dictate the order
my lord
there were 3 fights broke open
my lord I am not placing the Abhimanyu my lord Abhimanyu could my lord other my lord kindly consider your lordship
picnic court as a result of which the aggressor group to which the petitioners belongs attacked the other group, as a result of which one of them has died and the other one of them died and one Suryakant was seriously injured. As a result of which the FIR was registered for offences punishable under section 302/307, 148 and 149 and other allied offences. Since in the instant case there are eyewitnesses to the occurrences and there is an injured witness named Suryakant, I am not inclined to enlarge the petition on bail. However, liberty is granted to the petitioner to renew the bail plea after the examination of the eyewitnesses and the injured witness. The trial court is directed to do well to see that all the eyewitnesses and injured witness are examined within a period of 6 months hence, and thereafter the petitioner can renew the bail plea. With this observation, the petition is disposed of. Both the petition, 92 and 93. Yes.
Others they have not assaulted, your lordship. Kindly see there are 2 assault to 2 injured person, your lordship.
Okay.
Others are innocent, your lordship. They have not intention je sokale semanko sokale peitla je bhoji koriki asibe semane gote loko ko mari debe. My lord, kindly consider for the other, your lordship.
I pass the oath. Yes.
94 lordship mina ketano.
94 is over.
94 is
94
yes,
is
my matter.
94 is
Yes, my lord.
Boy.
Yes, my lord.
Yes.
Basan boy. Petitioner is in custody since 15th May 2024.
May 24. Huh?
Yes, my lord. May 24. And offense under section 363, 364, 307, 34, and 3 and 4 of Odisha Prevention of Witch Hunting Act, my lord.
307.
Yes, my lord. 307 of the IPC and 3 and
What are the allegations?
allegation is that the petitioner number 1 has offered a 100 rupees money to the informant son to come to the hill of the village. And when the son went to there, he saw that they were some putting vermilion on the head and 2 persons were standing there by holding axe. Out of fears, he shouted, and thereafter the villager came and rescued that boy, my lord. Actually, they were
planning to kill him.
Planning to for a body, my
Kill
lord.
that boy, 12 years boy.
For the goddess book, Kali, my lord, for body, my lord. But the son has been rescued. So far as 307 is concerned, no.
Right? CD
called for. Yes.
96.
96. Yes.
Petition is in custody, my lord. 13/1/2024, my lord.
Yes. 30?
13/1/2024, my lord.
13/1/24.
My lord.
Okay.
And offense under section 20B2C of NDPS Act, my lord. The quantity of guns is 152 kg, my lord.
152 kg.
My lord.
252 no 152.
252 kg, my lord. Nothing in conscious position in the present.
Charge on 3rd July.
Charge sheet also
3rd July 24.
3rd July 24.
Rejection 8/2/24.
Right. The petition is agreed by the when the rejection order is?
8/2/24.
8/2/2020.
Phase 8 in annex.
The subsequent thereto on 3/7/2024, charge has been filed. Therefore the counsel for the petitioner seeks to renew the bail plea before the trial court on the change in circumstances. Liberty is granted to the bail plea. Yes, next.
Maybe liberty, my lord.
Granted, yes.
Okay.
97.
Yeah, please.
Petitioner custody in 6/3/24, my lord.
6/3/24,
my lord.
24. Okay.
Charge sheet submitted 363, 366, 323, 506, 370, 34 of IPC. Read with section 6 and 17 of POCSO Act, my lord.
Custody, my lord.
From?
Custody is 27/4/24.
27/4/24.
4/24.
Okay. Offenses?
Offenses, my lord, 147, 148, 121, 121A.
307. What is 307?
307, nothing, my lord. Khali.
Unlawful activities, prevention.
Yes. Unlawful activities.
Explosive. Unlawful activity. Yes.
307 is not with me, lordship.
CD is there?
Yes, CD is there.
Yes.
But seizure is there, lordship.
It was live.
Live, that is live, all this.
Hmm?
Exclusive live was live, exclusive articles were there. seizure.
Recovered.
Yes, they escaped.
At his instance.
Yes.
That is the allegation, my lord. I have no antecedent even.
There
in my-
only, at this stage, you will have only allegations.
My lord, I have no antecedent even, my lord.
Maybe, but the allegations are serious. You are with Naxalites.
That they says, my lord, how, but they cannot prove.
What are the specific evidences?
Specific evidence, lordship, only when the search operation.
You just prepare it because
Yes,
it is serious
yes,
case.
yes.
I'll put it after 1 week.
Yes.
Prepare it.
Yes.
Because if he is entitled to bail, we will not give bail because see, it's Moist activities. And unlawful activity prevention act is also involved.
Yes, okay.
What are the what is the maximum sentence there? Section 18 and 20. That also you have to check. There may not be 307. 307 is not made out.
Not
because nothing is there. 148, 147, all these things are all right. The only thing Arms Act, Exclusive Act and
Exclusive Act,
prevention
yes.
of
Yes, yes.
yeah.
That was recovered from a jungle.
We get ready, yeah, up to 2. Yes.
Well, your lordship may fix it.
No, he'll give it. Yes.
May I please? Petitioner is a young boy of 26 years, my lord. Young boy of 26 years, my lord. He has been implicated in a case under section 20B of NDPS Act.
Recovery.
Below commercial quantity, 83 grams of heroin.
CD has not come, lordship.
Call for CD 1 week up.
এটা সিডি ପାଇଁ କେବେଠୁ କଲ୍ for ହେଇଥିଲା 83 grams my lord. Below commercial quantity.
I'll grant 100%. I'll grant bail below commercial quantity and all. But without CD on the record, I can't do.
CD call for ହେଇଥିଲା କେବେଠୁ?
And last final of 1 week.
Last
July 1 CD has the letter.
এটা সিডি কল for ହେଇଥିଲା 2/7 ରେ.
There are
I have asked
order
if they
up
have
to the coordinate
today
bench.
perhaps it is on the
2/7 ରେ ସିଡି କଲ୍ for ହେଇଥିଲା.
Friday.
And ଏଥିରେ ସିଡି ଆସିବାର ନାହିଁ ଏଟା ଆଜ୍ଞା ଏକ୍ସାଇଜ କେସଟା. This is an excise case. ସିଡି ଆସିବାର କିଛି ନାହିଁ ଏଥିରେ.
I'll tell you. Then on 2/7/2024, coordinate bench has directed to call for CD.
ସେ କଲ୍ for ସିଡି ମାନେ 2/7
without CD, I'll pass the order.
2/7 ର order ହେଲା they should have procured it.
That's right. That is a different story.
Just
But if there is an order of the coordinate bench, till that order is complied, I can't do it.
ଏଥିରେ କେସ୍ ଡାଏରୀ ଆସିବାର ନାହିଁ ଆଜ୍ଞା ଭୁଲରେ ଅର୍ଡର ହେଇଯାଇଛି.
କଣ କରିବି?
ଆଉ କେସ୍ ଡାଏରୀ କୋଉଠୁ ଆଣିବେ ସେ ଆଜ୍ଞା ଏକ୍ସାଇଜ କେସଟା. It's an excise case. Where from they will get the case date? So PR ଟା ତ I have got the certified copy.
Mr. Mishra, then counsel.
PR ଟା ମୁଁ ଫାଇଲ କରିଛି.
Petitioner submits that last case diary submits that on 2/7/2024, although the court has directed for obtaining directed the state council to obtain the case diary, but in this present case, no case diary could be procured by the state council. Rather, the PR,
PR ଟା ମୁଁ ଦଉଛି certified copy ଟା ଅଛି. ତାଙ୍କୁ ଦେଇଛି ନା ମୁଁ କପି ଟା ଫାଇଲ କରିଛି.
PR record needs to be brought on record. He has Mr. Mishra hands up the certified copy of PR dated.
ଦେଇଛି annexure 1 ହେଇଛି ପା.
ଆଉ କିଛି ନାହିଁ document ଆଇଲେ.
ସେତିକି ତ ସେମାନେ ଦିଅନ୍ତି ଆଉ କଣ ସେମାନେ ଦିଅନ୍ତି.
What are the other documents?
Other documents ଆଉ କିଛି ଏଥିରେ ନଥାଏ ଆଜ୍ଞା. Excise case ରେ ଏତିକି ଦେବେ ତା on the basis of that they will proceed. And it's a case 83 grams, 250 is the commercial quantity.
Final PR is not there. Final PR is not there, na?
Below commercial quantity ଆଜ୍ଞା ରହିଲାଣି 4 ମାସ ପରେ.
Submit that
5 ମାସ
submit that final transfer 1 week time may be granted to get the final PR. Final PR. Leave the matter on a 3rd. It is made clear that no further adjournment shall be given on this. See, 3rd, if you don't give, in any case, I have to grant bail. So, only this, there is an order, so therefore it has to be complied.
4 ମାସ ପରେ ରହିଗଲାନି.
3rd, 3rd.
102. May I please read, sir? 101. Now just CD came. 101 Bharatpur.
Okay, next week.
May I please read, sir?
Next week, he got the CD right now. He want to read it. So therefore, He's asking for an adjournment. Let it be on Friday then. What is the offense?
376 and 363, 366, 6 POSCO.
Okay.
But my lord, the 164 statement.
Okay, okay, Friday. Friday, let him. Friday. Same 21-year girl. Just see if they are in relationship.
Boy is 21 years, my lord.
Friday. Yes.
Let's see. Maybe there are some errors.
Yes, sir.
Petition is in custody, my lords, 10/10/2023, my lords.
10/10.
My lords. And last occasion, sir, to call for the case diary along with the 164 statement, my lords.
Case diary has come.
Yes, my lord.
Yes, sir.
That my lord, in this case, notice served on 24/7/24. That's it submitted, my lord. 7/12/23, my lord.
7/12/23.
Victim girl aged about 15 years, my lord.
The boy is 27. What does she says?
Allegation, my lord, as per FIR, my lord, petitioner gave a false assurance to marry her. And
1 minute.
My lord.
164. 164.
Married, on 16/9/23, बेले राम हेम्ब्रम मते फोन करे डाकिला मु घर बाहर की गली से कहिला कि आंबे माने बाहाबा मु बाहाबा पई राजी हेली नाही से मते जोर जबरदस्त साइकिल ले नै की कला ता घरे रखिला मो सहित
He was involved in that Odia papers.
Odia paper, not specific. There is no specific allegation against me.
Okay.
Where responsible only to throw the responsibility, the entire scheme was made, and the allegations were only in respect of GK and arithmetic papers, my lords.
But that's a big one.
With take board, board कर दीजिए, मैंने spacing कर दीजिए, take असुविधा है, छोटो कर दिला और छोटे ही I get.
So better I should read the evidence instead of
the charge sheet itself is only on the basis of charge.
Probably he has prepared it in keeping in mind other similar person who are in the queue, my lords. I
Not
only
the
segregated.
collector, not the
I
collector
consider-
and the other person who are main accused, my lord, not for the
Before I forget. Yes.
people blessed.
Pardon to mention, my lord, one serial number 140. The lordship has issued notice. A 1 day delay has. Notice has been filed, requisites has been filed.
Same requisites will be 140.
Accepted only.
Same requisite to be utilized for the purpose of serving notice on opposite. Least up to 140, na?
My lord, 140.
Yes.
47.
47. Okay.
47.
Yes. Have you checked up?
Checked up, but the injured, the victim has not appeared, my lord, not here, my lord. He will appear through BC. But the informant is here, my lord.
What are the injuries?
Injuries are there are 4 injuries, my lord. 2 injuries simple, head and my lord, other part body is simple, and nose and face, my lord, that is grievous. 2 injuries. And case, counter case, in counter case, all the accused persons are acquitted in view of the
settlement. Okay.
They have to file the copy of the judgment.
Okay. Also. See, what is his name? What is his name?
Ganesh.
Okay. For the same offense. Same FIR.
Same PS case number, same accused person who petition he has lost.
So what I'll do is, I'll leave this matter in that court. You will take care of.
First case was listed before notice. Second, subsequently it was listed before justice came up. And in that case, he has also not given any certificate.
Now, have you seen it?
This
File of this.
This is the order copy, and this file it with me. That the which file, that the court number 2 file.
This
is the order, man. In that
and
case.
when was that file? When that petition was filed?
Well, this petition was filed on 31/7/24.
When this is filed, there are three. This is filed on.
This is 11/6/24.
11/6/24. Against which order?
On XMPS case number, my lord.
No. Against the trial court rejected when? Trial court rejected the bail plea when?
In this case, trial court rejected on 19/4/24.
Here also 19/4. In this case 19/4. And what about that case? 7/9/66.
That is 11/7/24.
11/7/24. Then he moved another application, got it rejected, and
This
filed
application
another.
is filed.
And petitioner is in the present petition. Petitioner is agreed by the order dated 19/4/2024, whereby his bail plea has been rejected in FIR number so. Okay. So he has filed the present petition on dated
Present application on 11/6/24.
on 11/6/24. It's filed the petition on 11/6/2020. It appears during the pendency of the present petition, the petitioner has approached the trial court for grant of bail. Approached the trial court afresh for grant of bail. The state bail application was turned down by the trial court on
11/7/24.
11/7/24. 7/24. Against the said order, the petitioner again approached this court by filing ABAPL number 7966 of 2024. In the said petition, the petitioner has not disclosed regarding the pendency of the present bail petition being BLAPL number 6046 of 2024. Since the petitioner, it appears the petitioner has adopted sharp practice to mislead the court. Therefore, the present petition deserves to be dismissed with heavy costs. However, regarding to the fact, the fact that another bail the bail application 7966 of 2024 is pending before the coordinate bench, I feel it appropriate to list this application, the present bail application, also before the said bench, subject to the approval of the Honorable Chief Justice. Please the matter day after tomorrow before the said bench. Both the matters should go along with this, along with the BLAP. He will take the call. I have recorded here. 78. Yes.
Under 78, I have checked out that anticipatory bail. This is not applicable because their name was not in the affair.
Named names were not there in the file.
For that, they have mentioned that name was not there. It was also reflected in the order. Their name was not there in the affair, so anticipatory bail was given.
All of them.
Two.
Sir, accused number 11. The person who got the anticipatory bail, the accused number 11 in the affair. And
that was
in the affair.
In the order, I have marked.
Has not been. You might have said, you have said that in the court that their name is not there in the affair.
Sir, accused number 9, accused number 11, and accused number 17 is the name in the affair.
But my lord, what copy they have saw, my lord, that copy,
There
the name is
you
not.
misled there. Before that court, you said that your names are not there
that
and got anticipatory bail. Now he is telling the number of the accused. That is not our case.
Lordship, may I permit Lordship, accused number 9, accused number 11 in the affair, and accused number 17, those who have got the anticipatory bail.
That's what I am saying. But have you read the anticipatory bail application?
Yes, I am appealing.
You have said that your names are not there. Therefore, the anticipatory bail has been granted. And the order also says that. The first line, learned counsel for the petitioner submits that present petitioner has not been named in the FIR. That is what you have said in the that court and got anticipatory bail. Now you are seeking parity.
So they are not coming on the same.
See, these sharp practices doesn't work. Doesn't work. What is their role one after another?
My lord, I am giving a chart.
7.
I think all of them should go to trial court and do it.
Right.
Because of this. Why should I examine? Go to trial court.
In the meantime, charge sheet is filed.
When the trial, what about the charge sheet? When charge sheet was filed?
The 20/10/2024
No, means just before 3 days before.
No.
No.
No. The trial court rejected the bail application on 30th May 2024.
No, charge sheet was submitted on 29 as per his submission.
September.
Just a few days back.
Yes, sir.
Just all of you repeat because of your conduct is now.
In the motor 6 months passed, my lord.
Whatever.
My petitioner is also one driver. The West Bengal transporting the Jinsan.
Whatever.
Let's say more than 6 months custody.
6 months you have because the conduct is not
after vacation.
You mislead that court.
No, mistake.
You mislead that court. You say that your name is not there. Got the anticipatory bail. Now when a matter comes and you say that I am making number.
If there is a mistake, he has to come for correction. He has not corrected.
So therefore the trial court will look into it and the charge sheet is recently filed and all the applications were rejected during the investigation.
After vacation.
Agreed by the
6 months.
After vacation also.
Subsequent thereto on 20/48. No.
I beg pardon, my lordship.
The charge sheet in the present is stated to have been filed. In the changing circumstances, petitioner seeks to renew their bail would be a trial court. If the bail please file a press, the same shall be considered on the basis of the material available under court. With this observation, petition is disposed of.
I beg pardon, my lordship.
Yes. Who is saying?
I am saying, my lordship.
Oh.
That, my lords.
Sometimes
I am
confused.
My lords.
Yeah.
I am in sub item number 7, 11 and 19, my lordship.
Number?
Sub item number 7, 11 and 19.
You tell me the number.
Yes.
Case number.
Case number is 5114.
5114
of 24.
5114. Okay. What do you want?
And 6115 of 24.
Yes, tell me.
And 9377 of 24.
What do you want?
My lordship, as per the direction of Honorable Court previously, that I am filing this separately. But as per the direction, all the matter taken up in one row.
That's right.
And one item. My lords, in this case, I had not taken a grant opportunity to submit my matter, and I am not placing the.
You are now submitting. I understood. Your bail application is rejected on
even my lordship, I am not praying for parity, my lordship.
6/5/2024, your application is rejected.
No, my lordship.
Charge sheet is filed subsequent thereto. On changing circumstances, you go and.
My lordship, I know, my lordship, I am abide with the direction, my lordship, but at the view of the conduct, my lordship, even in this case, I am not able.
See, problem is 9-10 accused are there.
Yes.
And 6 accused are outside.
My lordship.
And you are tend to mislead the court and get orders.
No,
and
no, my
try
lordship.
to use that order in this proceeding. Therefore, I am not.
That is the separate, my lordship.
Whatever. I have passed the order. Next.
My lordship. My lordship, before passing the order, kindly heard me for a few moments, my lordship. Kindly heard me.
You save your
Because
energy. So
I am suffering. I am suffering, my lordship.
Save your within 15 days.
I am not misleading the court.
Because of that, I'll record one more thing. That if such
due to the file was attached, I am suffering, my lordship.
The same shall be considered by the trial court within 15 days from the date of moving the application. That also I've seen. You all of you will get the bail.
No.
But your conducts are not.
That, my lordship, discretion is
and some of the person.
Yes.
But my lordship,
I am behind for 6 months.
I'll tell you, trial court will give you bail. Don't worry. Go.
One of the accused,
that anyone who mislead the court, that I am also suffering, my lordship, due to attach the court.
You are in bad company. What to do?
But my lordship, as per the FIR is clearly indicated the name of the accused person. But what is the plea of the State Council when the conducting counsel of the petitioner submitted that?
Say that, you tell me, you look at the pressure of the courts. If you say we believe the lawyer, on that basis you pass the order.
It is the
Subsequently
duty,
find all these things
is
are
the
wrong.
duty of the conducting State Council to inform the court whether
It's very bad. See, the honorable judge has given you and given them anticipatory bail only on that.
on the ground that
your name is not there.
But it
And
is the
now he is
duty-
saying that 9, 11,
Madam,
and the FIR names are there.
But it is the duty of the conducting counsel of the state to inform the court.
Everybody has duty towards the court. One should understand that.
But I am
They should
suffering
suffer
due,
for
that due to the attach of the file, my lords,
Anyway.
or nothing else, my lords.
Okay.
But I am obliged with
15 days.
my lords, my lords.
Yes.
Obliged, my lords.
My lord, one more chance required for CD, my lord, because it is 306.
Charge sheet has been filed, my lord. Charge sheet
Yes,
filed under section 306 of the IPC, my lord.
Yes, yes. Charge sheet,
Yes,
CD has to come. Yes. Next.
106. May I please your lordship? May I please your lordship? 106.
105.
106, my lord. I am placing my the petitioner.
Who is appearing for 105? First, let us understand.
Sorry,
Who
my
is
lord.
appearing? In the, okay, in the 105 CD is called for. Okay. After 1 week, it will be taken up. Yes, 106 now.
May I please your lordship?
Yes.
The petitioner is in custody since 22 November 2023.
Yes. November?
22 November 2023.
Yes.
The investigation has been completed. The charge sheet has been submitted under section 376 2N 506 304B.
Problem there, my lord. Their side.
It's all right? Yes, yes.
Yes, my lord, the charge sheet has been submitted under section 306 2N 354B.
Mr. Behra, your voice is cracking.
Let him have the distance.
Yes, my lord, the present petitioner is in custody since.
Voice cracking, sir. Yes, pass it over. You want to say something? Okay. Pass it over.
107.
Yes, madam.
My please, my lord, offense under section FR was lodged, my lord, against one person. Offense under section 457 and 38 of IPC, my lord. And charge sheet has been filed against 2 person. Offense under section 457, 380 and 411 of IPC, my lord. And the present petition is, my lord, arrested, my lord, 4/5 of 2024, my lord.
4/5/24.
Yes,
Okay.
my lord. Allegation there, my lord, he theft some gold jewelry and silver jewelry.
What is the antecedents? How many?
2 antecedent, my lord. One is similar nature, another is.
Yes, sir.
My lord, that charge sheet submitted on 3/7/24, my lord, under section 457, 380, 411. During investigation, he confessed to have committed the crime, huge quantity of gold ornaments and cash.
In this case, confession only.
My lord, house of the informant by opening the lock of Almira, my lord. Statement has been recorded under section 27 Indian Evidence Act, my lord, and who led the place and gave recovery of the theft article, my lord. Apart from
What
that,
is recovered? What is recovered? Recovery?
gold ornaments, my lord.
Gold ornament.
My lord. Apart from that, my lord, that two criminal antecedent against the petitioner violate Rengali PS case number 258 of 23 under section 457 380, my lord, similar.
Similar.
My lord, and the another Sambalpur Rengali PS case number 40 of 24 270.
What is the recovery? You just see what is what are the gold ornaments?
My lord.
Huge quantity or small quantity?
That's your my lord.
You are on bail in the other cases.
Yes, my lord.
All the cases.
Yes, Mr.
While on bail you have done it.
Yes.
How many gold ornaments are there, my lord?
Yes,
I'm sorry.
my lord.
So many.
Yes, my lord. Page 14 and 15 is just not, my lord.
The problem is while on bail, in that case, you committed the similar. Okay. That's the problem. And recovery is use. Recovery is use. TI period, how many of them? I identified.
What so far the TI period report is concerned, that is not there in.
Tailored.
Custody since only. The problem, madam, just see the 13 items. How many?
Yes, my lord.
All are this thing recovered from you.
Already seized, my lord.
See,
Application and cash of 30,000.
after 3 weeks, least after 3 weeks, I think. Least of. No, when the charge sheet was filed, let me understand. When the charge sheet was filed.
3/7 of 2024.
Charge sheet filed. Objection log. Is a charge sheet when filed?
Charge sheet file, my lord, on 3/7/24, my lord.
You renew the bail plea. On 11/6/2024, the bail plea of the petitioner was rejected. Subsequent thereto, on 3/7/2024, the charge sheet has been filed in the present. In the changing circumstances, petitioner seeks to renew the bail plea before the trial court. If the bail plea is filed, the same shall be considered on the basis of material forms part of the charge sheet. With this observation, the petition is disposed of. Next.
May I please your lordship? The petitioner is in custody since 17/11/2022, and as per the prosecution story, on 16/11/2022, one Akash Khamari submitted a written report.
Is this the problem here or problem there? Because in the other center also the same thing happened. Maybe our problem. Huh? In our end. Yes.
May I please your lordship? This is a case under section 302 IPC.
I'll put it, I'll list it after 1 or 2 days. After 2 days, huh? Friday. Because there is a problem, I can't hear you.
Sir.
So let it be on Friday, and 106 be Friday. 107.
106 and 108, my lord.
Just check it, madam. It may be the problem at our end. Okay. Yes. 109. Yes, 109. Informant aided justice. Huh? Although the informant has been added as opposite party number 2 on request of the petitioner by the order dated 3/7/2024. However, requisites have not been filed by the petitioner. Even on call, nobody appears on behalf of the petitioner. What is the offense?
Offense, my lord, 376 DA, 376 2N, and 426 POCSO Act, my lord.
In view thereof, the
and as per rejection order, 28 witnesses.
December. Let it be present December. Yes.
110, my lord. I am in custody since 16/10/2022.
16/10/22.
22, my lord. In the meanwhile, out of 22 charge sheeted witnesses, 8 witnesses already been examined, my lord.
Yes.
Including the informant, and informant the wife of the deceased, my lord. This is the offense under section 302 and 506. My lord. Vital witnesses.
Yes.
And the mother, the deceased, and brother of the deceased and sister of the deceased did not supported the prosecution case, my lord.
Yes.
They stated the
Which part?
state.
Which part shall I read?
Kindly see Annex 3 series.
PW?
PW2 is the mother.
You come to page 17.
Yes, my lord, page 17.
Which part?
In serial number 2, my deceased son fell down at our house veranda as he was in intoxication condition by that time. And after this statement,
No, read.
my lord.
Read one line.
Yes, my lord. I am reading, my lord. He was in intoxication condition.
Deceased was at her parental house.
My lord.
So I, along with the other, shifted the
The deceased to the medical.
Yes.
At Qatar, during his treatment at medical, he died. The Lord PP declares the witness hostile and he is permitted to ask the leading
This is
question.
brother of the deceased.
Brother of the deceased.
Yes.
my lord.
Next.
This PW2 is the mother of the deceased, my lord.
Yes, I understand. Next.
Yes, next is the, my lord, PW5,
Yes.
the brother of the deceased, my lord.
He is also another brother.
Yes, my lord, another brother, my lord.
Hmm.
Hon'Ble.
Yes.
In the cross-examination by the defense, after the death of my father, in paragraph 4, after the death of my father, the pension papers were under the custody of my mother. The parental house of the informant is 1 kilometer away from our house. 1 week prior to the occurrence night, the informant had gone to her parents' house.
Yes.
That's why it is confirming that the informant was not present at the house during the occurrence, my lord. Both the deceased and the accused are quarrelsome by nature and both are drunkards. I, along with Sitaram, Bhavani and my mother were inside our house by that time. The accused had never assaulted the deceased. I was not examined by the police. Then, my lord, PW6. PW6, the sister of the deceased, my lord.
Yes.
I am reading, my lord, the paragraph 2, my lord.
Yes.
My brother Sitaram was present in my parental house at that time of occurrence. My father had retired from his service in the year 2015, and in the year 2021, he died. My father was getting 2,200 towards his monthly pension. There was absolutely no dispute between my brothers regarding the distribution of pension of my father after his death. I did not visit my deceased brother during his treatment. The deceased was a regular drunkard. After the incident, I have not seen the accused at my parental house or
Yes.
elsewhere.
Yes. Reading
And-
this, what do you want to say?
I am just want to say, my lord, nobody supported the prosecution case, my lord, and except informant, nobody is supporting. And I'm in custody since 2022, my lord.
Yes.
My lord, that only my lord deposition of hostile witnesses for to the state, my lord. That is my lord PW1, 3 and 4. A deposition copy not served to the state, my lord.
Why?
I have copy, my lord.
And,
I have also copy, my
there
lord.
are so many.
Why are you supplying selectively? Whichever supports you, you
Yes,
supply.
yes,
Which
PW
supports
no, my lord.
you,
Period 3 also supporting us.
Apart from that, my lord, there are so many eyewitnesses are there, my lord. Their statements are there and they are supported.
all of them are recorded.
No, that statements are there, my lord. Eyewitness statement are there. They are the material witnesses.
You supply the copy.
Their
then
examination
supplied, my lord.
is in
I'll
question,
put
my
it
lord.
next week. You supply, don't selectively supply.
Just supplied, my lord.
You supply.
Except,
Let
my
him-
lord,
let him-
except
let-
informant, nobody supported
Yes,
this.
yes. Next week, let the counsel for the petitioner supplied the evidence of the witnesses, those who have been already examined by the prosecution. Then counsel for the state seeks an adjournment for preparing the next week. Yes.
No bless.
May I please, my lord? The petition is custody since, my lord, 19/5/24, my lord. 19/5/24.
19/5/24.
My lord.
Yes.
The charge sheet has already been filed, but the allegation that the petitioner tried to touch of the private part of the victim, my lord, while they were sleeping in the roof. And petitioner parents and also the petitioner and wife and the
Charge sheet under which provision?
376 and my lord, 4 Poxo Act, my
Yes.
lord. He has attempted to touch the private part of the victim, my lord.
You are 40 years, sir.
Yes, sir. Yes, sir.
You are 40 years.
That's so. There's no attempt, there is no injury.
What are the allegations? Just see.
My lord, that possibly inserted my lord finger into the possibly
Then
inserted
attempted
the
to-
finger
Attempted, not forced.
into the
Whatever, 40 years and the child.
That's
My lord,
and I can't deny, but
that 164 statement also there, my lord. Medical examination.
medical is that is not
Whatever,
there.
40 years. Let the victim and the
Parents, but
parents be examined.
yes, sir.
After victim and parent examination. Yes. Yes, madam.
Custody since 7/5/24.
7/5/24.
5/24.
7/5/24.
Yes, madam.
Yes. Offense?
Offense rest is 506, 507, 294.
Yes.
Charge sheet file 47/24. Charge sheet 366, 376, 2 and love matter.
164 credit.
Victim 164 ta.
Credit. You are 22 years.
24.
You have written 24.
Victim 24.
Victim is 24.
Yes, madam.
You are 22.
Yes, madam.
Read 164.
The other.
And what are the allegations?
The allegation that the petitioner have the visiting terms to the house of the informant, and she disclosed that the persons whom he introduced, they eloped him, two persons, Nilakantha and another person, namely Aditya. Thereafter, he was arrested, and she disclosed that the
charge sheet file.
Charge sheet file.
Offenses?
376, 506.
Yes.
My lord, there are 164 statement is in Silkabar, my lord. I'm not. That allegation is very serious, my lord.
Serious.
My lord.
He's 68-year-old man.
68 years.
Charge sheet filed when?
29/6/24, my lord.
29/6/24.
24. Three 761.
Only 3761, my lord. Allegation of biting and
How are you related with the petitioner?
petitioner is the worshipping in her house and the factory, and having the visiting terms, and absolutely the medical report, no bodily external injury, having no insufficient evidence to opine recent sexual intercourse. Even doctor also opined inside that there is also no sign of teeth mark as it is alleged. No external injury on any body part. No sign of injury, no teeth mark.
But allegations are very.
The story which she has stated, my lord.
Prosecutor says something, you may tell story or
After 5 days, the affair has been lost. While I went to her house and
charge sheet filed when?
29/6, my lord.
29/6.
6.
The petitioner is aggrieved by the order dated 18/6/2024, whereby his bail plea has been rejected. Subsequent thereto, on 29/6/2024, the charge sheet has been filed. I am not inclined to entertain the enlarge the petition on bail at this stage regard being head to the nature of allegation. However, liberty is granted to the petitioner to renew the bail plea before the trial court on the changing circumstances. If such bail plea is moved, the same shall be considered on the basis of
permitted to withdraw
material
and
for
move the
part of
application.
the court. Yes.
Permitted to withdraw and move the
Yes.
application.
No, the same thing. I have not said anything.
Not-
Only liberty. I am giving liberty.
Not inclined.
So the not inclined was cut the not inclined.
Permitted to withdraw and remove
Permitted. Not in. Why should I?
40 may please, your lord. 20B2C, 50 kilo ganja, your lord. 50. Your lordship petitioner is inside.
50. Yeah, CD is there?
No, my lord, CD is not.
Call
Your
for
lordship,
CD,
charge
1
sheet
week.
has been filed.
CD, call for CD 1 week after. Huh?
Your lordship, it may be in 130, the connected and another accused is 130, your lordship.
Just see 130, the CD is there.
130.
130.
Okay. My learned friend is appearing for 130.
Co-accused.
Let him take another action.
130 or 114 দুইটার CD মাগি দাও 130 and 114 tag করিব সাথে দুইটা and list it up to 1 week. Yes,
Lordship, last since 1960 they are in the side the custody and charge sheet has been filed for that reason. A certain date may be fixed. A certain date may be fixed.
No, he'll give 1 week. Yes. Next. 150.
And Arjun.
Why?
They will obtain my lord the charge sheet copy and other statements.
It will go to November end. Huh?
Yes.
November end. If see, listen, when your charge sheet has been filed.
Yes, yes.
When?
Copy is not available.
Date, give me the date. Charge sheet date.
No, my lord, of that, in here, my lord, the testimony up to testimony revealed that investigation is going on, my lord.
Still investigation is going on.
Going on, my lord. That is up to city with me.
Date. Last CD.
Up to 23/7/24, my lord.
Oh, then you renew because see your
Yes.
bail application was rejected.
Grant liberty.
Nascent says.
Grant liberty to
Right.
move application.
Petition is executed by the order dated 30/5/2024. Whereby his bail plea has been rejected. The investigation of the case is still going on. Therefore, I'm not inclined to enlarge the petition on bail. However, liberty is granted to the petitioner to renew the bail plea immediately after the charge sheet is filed. If such application is moved, same shall be considered on the basis of the material form part of the charge sheet. Yes. 160.
Me pleasure was. The petition jail custody since 9/6/24.
9/6/24. Okay.
The offense is triable by magistrate. Offenses are 409 and 420 IPC.
Yes.
Petition is the secretary of the society under Daspala block. The allegation against this petitioner that is irregularity in paddy procuration operation. Paddy procuration operation. Paddy the shortage is society. Not misbehavior of cash.
Yes. What is the amount of misappropriation according to them?
Misappropriation of 509 quintal, 509.82 quintal paddy.
And that is the rupees, my lord, 11 lakhs rupees, my lord.
11 lakhs.
That the accused Raghunath Mahakod cunningly entered the wrong data in the record with intention to cheat the innocent farmer and committed criminal breach of trust to innocent farmer, where he entrusted with the property of paddy of farmers as a society secretary, but for his personal benefit, misappropriation the property and the criminal breach of trust to farmer during course of investigation, my lord. Sees the detailed list of the farmer in presence of the witnesses under the proper procedure, my lord, where accused Raghunath Mahakod has received 509.82 quintal of paddy from 12 farmers at Mandi, but no cash has been credited to their account, nor the said paddy was found available at the
What is the stage of investigation?
My lord, stage of investigation, my charge sheet submitted, my lord. Charge sheet submitted on 2/7/24, my lord.
2/7/24.
Yes, my lord.
You have
farmer
taken the money from the
no.
For
the farmer not lost the FIR. The FIR lost by one area officer of the
statements of the farmers.
And another thing, my lord, 12 farmers, allegation 12 farmers, and 12 number of farmers has given affidavit. They got the received the money. That is the affidavit.
Why have you obtained affidavit from them? Why you are collecting evidence?
I have not collected.
Then who has got that affidavit? Was it your job? You are in custody.
Yes, madam.
You are collecting affidavit from the farmers?
No, farmers.
Why are you collecting?
It's not a part of
they have to do it.
It's not a part of investigation, madam.
You are procuring evidence by way of this defense. This shows you are
Yes, charge sheet file in Lordship.
What is charge sheet file? But
Charge file
you can't do all these things. This is completely, that shows your involvement. You repeat your bill up. Charge sheet file on?
My lord, charge sheet file on 2724, my lord.
2724
under section 420.
If you undertake to pay back the money to the poor farmers, then I'll record it and bill. Otherwise, you repeat your bill. You can't take, see the poor farmers, you take away their money, paddies and all. See, amount is 509 quintals.
Yes, let's keep this matter tomorrow, my lord.
No, not tomorrow. You repeat your bill. Right on. The petitioner is agreed by the order dated 17/6/2024, whereby the bail plea has been rejected during the investigation, when the investigation was going on. Subsequent thereto, the charge sheet has been now filed on 2/7/2024. Therefore, on the changing circumstances, petitioner seeks to renew the bail plea before the court below. If such bail plea is filed by the petitioner, the same shall be considered on the basis of material formed part of the charge sheet. Yes, with this observation, and within 15 days from filing the application, within 15 days. Yes.
17.
Please, my lordship. Offense 498A, 3.0B, 3.2.
302.
Yes.
Yes.
The petitioner
302.
since January 20
Yes. Yes.
in custody.
Charge sheet filed?
Yes.
When?
Charge sheet already filed.
25/4/23, my lord.
25?
4.
4/24.
23.
23. Okay.
Offense 302 and
Yes.
498A.
My lord, offense under section, my lord,
302.
498/302, my lord. Charge sheet submitted, my lord.
Yes. What are the allegations? Husband? He is husband.
Yes.
Yes, sir.
What are the allegations again? Custody since? Custody?
Custody since January 7, 23.
7 January.
It's 21 months.
Yes.
Custody.
Yes, see.
164 statements of some witnesses are there, my lord. That is not, my lord, legible copy not supplied by the IO, my lord.
Shall I keep it after 1 week?
1 week list.
You just see
Only,
whether 30.
only statements are there, my lord.
Oh, just check it up whether 302 is in fact made out or not.
My lord, just I am reading one statement of the witnesses, my lord. That
he is already there in custody about 1.5 years.
the statement of the ମୁଁ ଶିଶିର ଛଟେଇ ଆଖପାଖ ଗାଁରେ ଜର ଥଣ୍ଡା ହେଲେ ଲୋକମାନେ ମୋ one statement of one ମାନେ treating physician, my lord. ଲୋକମାନେ ମୋ ପାଖକୁ ଆସନ୍ତି, ମୁଁ ମେଡିସିନ ଦିଏ। ଗତ ତା 1/1/2023 ତାରିଖ ସକାଳ 3ଟା ହେବ ମୟୂରପଦା ଗାଁର ଲକ୍ଷ୍ମଣ ରେଡ୍ଡି, my lord, ପିଟିସନର ମୋ ଘରକୁ ଆସି କହିଲା କି ମୋ ସ୍ତ୍ରୀର ଦେହ ଖରାପ ଅଛି, ଆସି ଟିକେ ଦେଖେଇ ଦିଅ। ମୁଁ ତା ସାଥିରେ ତାଙ୍କ ଘରକୁ ଗଲି। ସେଟା
custody.
Yes.
And the offense, my lord, 20B2C of NDPS Act, my lord.
But
quantity, my lord, 1 quintal 30 kg. And petitioner is the driver of the offending vehicle. And
what is the stage?
Stage, my lord, in the meantime, only one witness has been examined.
Only one?
Mine.
Yes.
My lord, update CD is required, my lord.
Update CD. Yes. And status of the case also.
My lord.
Yes.
They are, my lord, short date, maybe given 2 years, 5 months.
Yes.
Inside custody.
May I please jealous? My lord, offense under section 307, 302, 506 and other allied offenses are there, my lord. Allegation is that, my lord.
CD, call for CD. Okay. Next.
120.
That may be fixed.
Yes.
In this case, the petitioner is in custody since 27th of May 2024.
27
May
24, huh?
My lord.
Yes.
Charge sheet submitted under section 3762N 506 of the IPC. The victim is 21 years old petitioner is 25.
No,
And
164.
in 164, she stated that since 3 years back there was love relation, and subsequently she got pregnant. And when the dead child was born,
Why don't you read it?
Aye.
Read it. 164, you have
Yes,
read
yes,
it. 1 minute. please.
କାହ୍ନୁ ନାୟକ ମୋ ମାଉସୀଙ୍କ ପୁଅ ହୋଇଥିବାରୁ ଆମେ ଦୁଇ ପରିବାର ମଧ୍ୟରେ ଯିବା ଆସିବା ରହିଥାଏ। ଆଜକୁ ପ୍ରାୟ 3 ବର୍ଷ ହେବ ଆମ ଦୁଇ ଜଣଙ୍କ ମଧ୍ୟରେ କଥାବାର୍ତ୍ତା ହୋଇ ଭଲ ପାଇବା ଆରମ୍ଭ ହୋଇଥିଲା। କିଛି ଦିନ ଏମିତି କଥାବାର୍ତ୍ତା ହେବା ପରେ ସେ ମୋ ସହ ଦୈଥିଲା। On 5/4/2023, the FIR was lodged after 9 months, my lord, on 7/1/2024. My lord, after 5/3/2020, 5/4/2023 is the earliest date of incident. As per the version of the victim, FIR was lodged, my lord, 7/1/2024. In the FIR, 5/4/2023 hela incident.
Okay.
FIR dele 7/1/2024
This is a minor.
against one
So
Ajay
once-
Pradhan, against one Ajay Pradhan, not the petitioner.
Ajay Pradhan.
Subsequently, she developed in the 161 and 164. She stated that
Yes. let's just see.
I have given the copy to state.
Requisites not filed.
Requisites.
Notice to the opposite party number 2 was
I will file it by tomorrow.
issued by order dated 3/7/2024. However, due to want of requisites, the notice could not be served. Mr. Mishra, learned counsel for the petitioner submits that he would be filing requisites
By tomorrow.
Tomorrow, leaves the matter after 3 weeks. Yes.
After vacation.
123.
May I please read? The custody since 14/8/2023, madam. Custody since 14/8/2023.
14/8?
2023. And date of occurrence, my lord, 10/8/2023. The offense, my lord, 3762F and 506, my lord.
Yes.
The present petitioner,
376.
my 2F.
Milord, here, Milord,
58.
father-in-law, Milord, committed this crime against her sister-in-law, Milord. Page 21, I am placing the 160.
Since 12/1/2022, Milords. And those charge sheet has been submitted since 10/5/2022. But there is no progress, no trial has commenced as yet, and it has not been committed as yet, Milords.
Yes.
I am in custody since more than 2.5 years. Offense under section 302.
Here, Milord, here, present petitioner killed his second wife, Milord. Eyewitness, his mother, his son, his father, and all are eyewitness. I am placing one statement as mother, Milord.
1 minute. The petitioner is agreed by the order dated 9/5/2024, whereby his bail plea was rejected. Subsequent thereto, the RC has been filed on 10/5.
Last Panchi by, yes.
10/5/2022. No, subsequently to 24.
22.
Or 22. Okay.
Vice.
Read the evidence.
Milord. First, I am placing the statement of mother, Milord. More Hema Koran.
I pray for an adjournment, my lords.
On request, adjourn.
129.
My lords, in this case, inadvertently, if I've missed filing the requisites, my lords, notice has to for offense under section
Since the-
376AB.
The by the order dated 4/7/2024, notices were issued to opposite party number 2 oblique informant. However, due to want of requisites, the same could not be issued. Counsel for the party petitioner seeks 1 week time to file requisites. Leaves the matter after 3 weeks.
Obliged, my lords.
4 weeks.
131.
130.
131. May I please, Lordship? Lordship, here the petitioner is in custody on 3/12/2023, my lord. Here the offences are 341, 294, 452, 323, 307, 506, along with
Custody since?
Custody since 3rd December 2023.
Yes.
The charge sheeted offense, charge sheeted under section 307 along with other offenses.
CD টা আসেনি আগে।
CD, call for CD.
Please sort that, my lord.
Yes. Next.
132.
Good.
132, my lord, I filed the requisite today. Unfortunately, I have filed an extract about order was to notice through register post. My lord, today I have already filed, my lord, the
Notice was issued.
and no notice. As today I have filed, my lord, the requisite, my lord. So notice may be.
No, issue notice to opposite party number 2. Returnable.
Today I have already filed the requisite.
Yes.
That may be.
The counsel of the petition. Notice was not issued. How we have filed a requisite?
Now, your lordship has directed for issuance of notice, but I have not filed the requisite.
The counsel of the petition.
Delay.
That he has filed the requisite today. Same may be utilized for the purpose of serving notice. Yes.
133.
133. Yes.
Milord, 133 milord, 420 kg of ganja CD is required.
My lord, CD already, my lord. Your lordship may kindly turn to your lordship's order dated 27/8/2024. I have approached your lordship.
No, this is 27/8/2024.
Yes.
There was an report sought from.
My lord, out of 38 witnesses, only 4 have been examined. And I am in custody since 9/7/2023.
2023.
And released on bail twice on interim bail, my lord, and I have surrendered in time.
Yes. There are 38 witnesses, 8 witnesses have been.
Only
examined.
4.
8 witnesses.
8 in between.
8 witnesses have been examined.
Expeditiously, my direct to.
Expedite. Hello.
Just see how many witnesses you want to examine.
CD is not there, so that's why, my lord, I have.
After 2 weeks.
Yes,
call for
CD.
My lord, may I pray your lordship may keep it to next week?
Next week may not be possible.
Next week.
Next week. Next week.
Oblige.
Yes.
Wonderful.
Bill complete.
Right.
May I remind, I'm
Yes,
irritating your lordship.
where is the other side?
Yes, other side you are sitting there in the bench.
Yeah.
Yes, he has come. I am grateful, my lord, to my London friends. Dear my lord, I'll not take more than 2 minutes. I'm not on merit.
You will not take 2 minutes, but the volume of.
No, my lord. Lordship will see the complaint.
I have already heard. You are covered by the judgment, but he wanted to.
I am not fully covered. The complaint itself is not mentioned. A complaint has been filed without any affidavit, without any verification before the lower court. And your lordship will see the complaint.
1 minute, I understand your case.
Yes.
Reiterate that.
The amount involved is more than 34 crores in one case. In another case, it is more than 32 crores. And there is a delay of finding that it is.
What is the delay?
Delay was in one case, in 2163, there is a delay of 17 to 328 days.
17.
And in another case, 2164, it's delay of 18 to 239 days.
What is the amount you said?
It's more than 34 crores in one case.
34 crores. 1 minute, answer me one thing. 34 crores is hyphened. Why? What is the use of this huge amount telling? 34 crores TDS deducted by him, deposited with interest with you. Try to appreciate. You have to answer this very pertinent question. What is the loss to the government? Rather, government is in a beneficial position. Why I will tell you. This aspect, Mr. Rai is also not addressing, neither you are addressing. He has deducted TDS from his clientele. He was supposed to deposit with you, and the deductee was supposed to get the benefit of that. because of delayed deposit, you got the money as a revenue, you got the entire money along with interest, and the deductee was deprived, he could not get the benefit, as a result of which who is then benefited? Who is benefited? The revenue is benefited. Revenue is doubly benefited. Why revenue is doubly benefited? First of all, got the interest. Second, the deductee could not get the benefit. So the revenue is doubly benefited. How will you address to this? Act, forget about act, you answer it. This is fundamental jurisprudence. And you say 34 crores. Lost to whom? Rather, you got benefited. Because the deductees have not claimed a single rupee. If deductee would have claimed, the government would have given that benefit.
They have to claim. They will not get that amount.
Or they can very well resort to recovery proceeding. They can prosecute them for cheating, whatever. But you are not able to answer me how many deductees have come to you. Under the aid of 276B, you are trying to prosecute. There is no loss to the exchequer. Rather, there is a huge gain.
Pursuing now to the act,
Act, though, you have already addressed. But this aspect, who will answer?
For detective point of view, I am not arguing this matter. I am arguing that if this act, why this act has been provided. Because if they want to do that.
See, all the judgment which you cited and he cited, nobody has taken care of this situation.
Correct. Absolutely.
In that light, you just enlighten me so that I can write a judgment on it. I will request you also.
Well,
did you follow what I am trying to tell?
Yes. When my submission is, when the revenue is neutral, what is the purpose of launching the prosecution?
No, revenue is not neutral. According to me,
advantage position.
Advantage position in the sense got the interest.
Yes.
As well as deducted did not
Yes,
claim.
ma'am.
So therefore, that money is also gone to
Balance.
their
That
pocket.
will be a wonderful judgment because for the first time this judgment will come.
You assist me that I was pondering over this. I thought
Madam,
this is a unique situation.
Yes, ma'am. Second is, Lordship, please, for a
I'll keep
minute.
it day after.
Manners, day after tomorrow, manners, definitely.
You just ponder over.
Manners, may I just
Let the judgment order come and we can follow that order.
No. In that judgment also, I want to deal with this point.
Yeah. Manners,
If you can assist me.
may I, with your Lordship's kind permission,
Yes.
just with your Lordship's kind permission, pray your Lordship to kindly see Annexure 1, the complaint petition. Lordship may kindly see for a minute.
See, in the SOCAS notices are issued.
No.
You file the reply, they don't deal with that.
Manners, no. The complaint petition which has been filed,
Yes.
it is without any affidavit, without any verification. Lordship will kindly say the GSO. Yes, it is required. Yes, it is required. No.
Regularly we are before the law.
Oh, that is a Thomas. See, Bishop Haileboni, Samaste Bishop Haileboni. Yes. Where is the point? Where is the statute?
In that crowd.
You read that position, that.
My lords, I am saying, my lords, Lordship may kindly see the GSO criminal.
Item number.
GSO criminal, I am saying, showing my lords.
Yes.
That is 20.
Are you covered by that Priyanka Srivastava?
Yes, I am covered. That's Lordship is correct. I have given the compilation balance. Balance is a
Priyanka Srivastava.
Yes, Priyanka Srivastava. I have given that judgment in my compilation page 94 of my compilation.
Yes. I have to deal with Priyanka Srivastava.
Yes, by Supreme Court, my lords.
Yes, we.
My lords, Lordship.
Complaint.
Yes, 30 out 31 sir dekhibe ebong sir dekhibe. It is without any affidavit. Now, page 94 रे कहला ये जो compilation ता देखिली sir ठीक Lordship may kindly see Priyanka Srivastava versus State of UP 2015 volume 6.
Yes,
yes, ma'am. That thoroughly covers The complaint petition
You
absolutely
deal with
not.
this also, huh?
Yes.
Yes.
Lordship may resolve the judgment and.
No, day after tomorrow, you address the one which I have told you.
Day after tomorrow,
Day after. You address that issue. Which
yes.
You will answer Priyanka Sewal. Yes. Weekly.
I'll again mention matters day after tomorrow.
But come with the judgment in that line which I told.
Yes. When the revenue is in the advantage position.
Is it a case of unjust enrichment?
No. That also. Is a case of unjust enrichment by the state. By
That
the
you just enlighten me whether it's a case of unjust enrichment or not.
Miles.
Because this money is not belongs to the revenue. Money belongs to Directive.
Yes.
If it is not claimed or not given,
Yes,
it may be a case of unjust
yes,
enrichment.
they will get. Yes, they will
just
get
address
the,
on that issue.
Yes, they will get the benefit so far as the TDS is concerned because they have to file the claim the TDS
After the financial year goes, they can't claim. So
No.
So then
they can claim when I am depositing it after sunwork. After
time limit for filing a return.
return by that time return is filed already.
Return is filed
By Directive.
Yes, return
without claiming.
Without claiming, my lord. And later on they can get that benefit. That is they have amended the section later on in 2013.
Show me that provision.
Yes. Huh?
Show me that provision.
Yes.
If there is a provision subsequent that the Directive can claim also.
Yes. Suppose I have deposited it and they could not claim it. Later on, if I have deposited it, they can claim.
In the subsequent financial year.
Yes, subsequent financial. I'll show that because that came after 2013, following a judgment of the Kerala High Court.
Oh, you just tell me.
I'll.
Yes. Start call.
136.
136. Yes.
Vigilance case.
Rejection of my discharge application is subject matter of selection. I am in the relevant point of time serving as district medical Ayurvedic officer. Now the prosecution allegation is that one Balabhadra Das, he did not attend the office or did not dispensary at a particular place, Malda, from 2009 to 13 and draw salary.
Yes.
That's the allegation. My period covered for 3 months. That is March, April and May 2013. In that respect. The procedure is that he has to send the duty certificate. On receiving, I will disburse the salary. For this 3 months, the prosecution himself says that certificate has been received through registry post in the office of the district Ayurvedic medical officer in which I was in charge, and they in fact seized it.
Yes.
Their only allegation is that this receipt is not showing in the issue register of the person who sends it. Hence, I have been arraigned as an accused.
It's a case, first of all, he has not given the correct certificate in respect of earlier filing by the petitioner
Earlier filed what?
earlier filing of
Same cheese.
सेम केस रे ये फाइल करछंती सीआरएनसी फाइल करछन नै किंतु गोटे केस फाइल करथिले सो फर एज आई रिकलेक्ट एंड अदर कोएक्यूज पर्सन्स
I don't know.
To the charge.
No, my lord.
What
This
was
order, I have not.
so far as the another accused person has challenged that, perhaps that has been rejected. So far I recollect, I was conducting
Same impugn order.
same case re.
No, my lord, not same impugn order.
Impugned order
But
no.
he has also moved a discharge application which was rejected.
He has not given certificate. तेणु देखिन आउ so far as this petition is, it's a case of 431C and D and 409 120B. All the accused persons connived with prosecution story in nutshell is
120B.
Connived with each other and given benefit to a person who has never discharged his duties for years together. And they, his petitioners, earlier predecessors have visited the spot and conducted inquiry, supervision, and they have found out the fault, and they have also released the fund in their favor. So this petitioner has also relieved his period and period relating to his predecessors also. That's what the predecessors earlier refused. The why it was retained, why it was not released. He could have verified the same. And in fact, despite that without certificate, absent statement, that has been released. And everything they have committed fraud, and it's a case of 120B. How it will be?
He was for 3 months. That
Yes.
is
3 months.
March, April.
नहीं 8/4/13 ରୁ 31/11/2013 से किंतु से मार्च एप्रिल मई जून प्लस एरियर भी अलाउ करछन.
Let's see. Original working certificate has been seized in the seizure list at page 60.
Now, what he says, you have sanctioned the thing which was prior to that in the sense.
No.
March, April, May.
No, not like
page
they themselves allege that is 1,32,000 I have released. This is
1,32,000 pertaining to which period?
Pertaining to the period March, April, May, June. That's the case. Well,
So
they themselves seized. Now they are digressing. Their FIR I have annexed.
Charge sheet, your lordship kindly see. 51, page 51.
Page 51.
6. Serial number 6. The role of the petition.
51, 1 minute. Serial number 6. 51, huh? Okay. Yes.
Serial number 6. Table there. Your lordship kindly see the table.
51, yes.
Tabular format दिया है
Yes.
Total 2,08,582 anchor period release है. And your lordship kindly
which is it?
table रा जो total.
Total 2,08,582.
Yes. So the लक्ष्य केते जोटा कोन that is not correct. तापर मार्च टिके
आया मार्च मासरे मु नथिली. मार्च मास पेमेंट टा आसी ड्यू होला मो बेले मु रिसीव री करछि. कोन
March to June.
Yes, my lord. That's exactly my case.
You were already there.
March से April, May, lordship got it.
And June.
June,
Yes.
then arrear DA from January to April. And the entire period lordship kindly. तांको predecessor ता पूर्वरु अछि. Total period ता होछि period of एटा से जो काम करि नाहति नै चंती. That is relates to
9 to 13.
2009 ରୁ 2013.
2009 ରୁ
2013. ମାନେ 4 ବର୍ଷ. ତେଣୁ he could have
in 2013 from January
to June पर्यंत ही देई चंती.
till June, January to June.
हां किंतु आंकर पीरियड होचे 8/4 ରୁ जॉइन करले 30/11/2013 पर्यंत.
8/4 ରୁ 30/11 नवंबर.
No, she was in service. किंतु 4 वर्ष धरि कि से नथिल ता पूर्व पीरियड काहे कि डिटेन थिला unless and until it shows the circumstances show that it's a case of conspiracy. Case of conspiracy it should be tried.
A 1 ରୁ 4 जो रेरियर था your lordship 13 is the I'm on.
How have you released the arrear if he has not worked?
No, my lord, on the basis of the certificate, yes.
Who has given the certificate?
Your lordship, the certificate has been, the working certificate is issued. I am.
That's the conspiracy they say.
No,
that not working certificate was genuine.
I am not.
On that basis, money is
my lord,
transport.
My lord, there has to be a rule. The rule is that on receipt of the certificate, I have to pay. But there has to be a direct restrainment that I should not pay even if I received. That is not the case.
You don't verify the certificate also?
Yes. The certificate is there. No, nothing. Certificate is original certificate has been seized as per their seizure list. As per their seizure list, they have seized the original certificate.
Where is the narration about him in the
page 6 re lordship changes. Same page.
Same page. Yes.
Petitioner was working as a ADM of Keonjhar and was also drawing and disbursing authority of the said office for the period 8/4/13 to 30/11/13. He was the disbursing authority for that period only. Paresh Kumar Das was working at the head clerk of the said office from the period 30/11/2012 to 15. D then petitioner had prepared the pay bill. This petitioner prepared the pay bill for the month of March 2013 to June 2013 and then
your own defense is the certificate.
Oh, my lord, I have to prepare the pay bill on the basis of the certificate. That's my official duty.
That certificate has to be tested in the.
No, the certificate.
How it was generated, who has given.
Certificate.
All these things has to be tested.
They are not disputing the genuineness. They are saying that's not in register. Not a single word is questioning the genuineness. On the contrary, the seizure list contained original working certificate.
Show me somewhere.
60. Page 60, my lord, seizure list.
60.
60.
The genuineness of the. They say that is genuine.
No, not a single word. Genuineness.
They will not write a judgment. It has to be.
No, my lord. In the imputation has to be.
Imputation is there already.
No, my lord. Imputation I have quoted in my
Imputation
petition.
is you have released the
No, the imputation.
Despite the fact that the
Despite
gentleman was not working.
No, despite the fact that I have this working certificate is not there. My lord, I have quoted it in my page 8 of my petition.
No, from here just to me.
My lord, that's a FAR I have quoted.
From pleading authority, I'll decide on the
pleading.
basis of pleading. From the charge sheet, you show that case is not made up.
My lord, I'm quoted from the charge sheet and
read. Show me the charge sheet. Charge sheet is there with me. Which part you have quoted? Show me the charge sheet.
My lord, charge sheet.
ସେଇ ପ୍ୟାରାଟାରେ ଲେଖା ହେଇଛି ଚାର୍ଜସିଟର ଲର୍ଡସିପ ମେ ପ୍ଲେସମେଣ୍ଟ
I have quoted that actually.
ନା ସେଇ ପ୍ୟାରାଟା ଦେଖନ୍ତୁ ଜୋନ୍ ତ ମିଶ୍ର
Registered, my lord. Scrutiny of the register, lordship, page 46.
46.
Page 46, second paragraph.
46. Yes.
Scrutiny of the register letter received from the year 2009, 10, 11, 12 and 13 of the office of DAMO Keonjhar reveals that the working certificate of Dr. Balabhadra Das, ex-AMO, GAD so-and-so Keonjhar, for the month of October 2009 and July 2010 have been received in the office of the DAMO Keonjhar, white registered letter received so-and-so, white serial number so-and-so, respectively. Then working certificate of Balabhadra Das, so-and-so for the month of March 2013, white letter number 10 dated 20th March 2023, April, similar there is a date, May there is a date, June have been received in the office of DAMO Keonjhar, white registered letter received by so-and-so, respectively.
But on cross verification.
My lord, this is important. But on cross verification, it is found that the above working certificate of Dr. Balabhadra Das for the month of April have not been shown in the issued in the register of letter in the GAD Malda. My lord, I am not the person who is keeping there. Please, my lord, he has sent the document, this document received. It is not shown in his register. What liability can be first? My lord, I have not done anything in and there is no dispute that is genuineness or otherwise.
Further read.
Yes, my lord.
The false letter numbers.
So false. Now, thus from the above scrutiny, the record it is found that Dr. Balabhadra Das is not submitted his working certificate. So the inference is drawn because the issue register doesn't contain. The entirely it is based on inference and surmises. The lordship kindly have that. Again, I'm reading. For the have not shown issued in the register of letter issued of GAD Malda. So false letter number have been put in the said working certificate. So it's only the inference. So question here is that I am required under law to make payment upon receipt of the
what law you are showing?
Well, there is a procedure.
Show me.
That I'm searching that is a so.
Show me that any document is placed before you.
Yes, my lord.
Without irrespective of verification and all, I can release it.
No, I can release upon receipt of the working
and
certificate.
That is found to be false.
False is not there
in the trial, whether it is false or not.
False is not that. My lord, the fact now, let us not dispute.
From verification, it was found that letter number and everything was
no,
false.
Let's not. They are not saying false. They are saying that issue registered has not mentioned it. Hence, it is false. They are not digging out anything contrary material to show.
These are
my lord, I will show the
complicated facts to be.
No, my lord, there is
out in the.
My lord, these things as it is there. I am not.
You show me the rule that.
My lord, I am showing.
Your job is only to see the certificate and read.
Yes, my lord. That's the procedure. My lord, it's a procedural rate of.
Show me. That is the only case you have.
My lord, that is up, and I am
nothing else is required to be shown.
I have actually searching out for that.
You tell that the original certificate is given.
Yes, my lord.
I am not there to inquire about the veracity of that.
Absolutely.
I will act upon that and release it.
Exactly.
You have done it.
My lord, that
yes. Subsequently they found that to be false. I am not responsible.
My lord, I'm I am actually searching out for that document.
That is the only thing you have.
That I will have to produce.
Otherwise you don't have a case.
Yes, madam. Because the police has not also seized, the vigilance has not also seized.
Police will not find out your defense.
No, they are not finding out the defense, but they are
Police will start reading rule.
My lord, this is only all right, my lord. I am not joining.
You have
place that rule. I will place that rule.
The police will start reading rule, then they have to fight right.
I'll place that rule
and start acquitting people.
I will place that rule.
I know. Then 2 weeks, 3 weeks. 2 weeks, 3 weeks. 2 weeks. Yes. That is the only thing you have to show me.
Right.
137. Yes.
137 as per the direction of last.
There is an interim order in this matter. Interim order in that matter.
Filing the charge sheet, my lord. Last occasion also directed to file the charge sheet.
You file it?
My lord, I'm filing.
Bring it on.
My lord.
Bring it on. Then counsel for the petitioner seeks to bring on record the copy of charge sheet. The same may be done with maybe leaked out. Yes. 138.
Wait, please. 138, the petitioner was running a ultrasound clinic. A show cause notice was issued for violation of the PCPNDT Act. Simultaneously, a 1cc case was instituted. I contested the same, got acquitted. Thereafter, I applied for renewal of my license to run the clinic. The state filed an appeal. That appeal, the state is not taking any steps. Time after time, they're delaying it. I filed for a renewal of my license. In the RTI, they say, since the appeal is pending, I cannot give you license. They're not pursuing. My only...
that appeal should be expedited.
The appeal should be disposed. That is the... Yeah, it's a copy of each.
Judgment is here.
No, it's
appeal filed before?
Before, my lord, that appeal is...
Additional session.
Yes.
What is the stage of the appeal?
Lord, LCR has been called for that. That is, I've attached the order sheet at page 32. Early disposal. Early disposal.
Unless experience the disposal. Right. Petitioner is. What are you challenging then here?
No, I'm just seeking for a direction to for early disposal expeditious.
Petitioner is in this petition. Petition is exploring the following. Mr. Maharana and counsel for the petitioner submits that he was prosecuted in 2cc case number 1 of 2015 for what was the allegation there?
For offences under PC and PNDT Act.
For the offences under PC and
PNDT Act.
What is full form?
That prevention of prenatal diagnostic.
Under section 23 and 25 of PC and PNDT Act.
Yes.
Act. By the judgment dated 14/5/2019, passed by the SDGM.
Yes, ma'am.
SDGM Khurda.
Yes, ma'am.
He has been acquitted. He has been acquitted? Or?
Yes.
They have been acquitted.
But the petitioner has been acquitted.
Petitioner has been acquitted. Subsequent thereto, the petitioner has filed criminal appeal, being criminal appeal number 29/60 of 2019, before which is pending before second additional sessions at Khurda. Mr. Maharana, counsel for the petitioner submits that he has applied for renewal of his license to run the nursing home.
Yes, for the ultrasound clinic.
Ultrasound clinic.
Yes.
Nursing home, ultrasound clinic. However, this the license has not been issued to him.
Renewed.
Renewed to him on the pretext that the appeal is pending.
Criminal case is pending.
Appeal is pending. Criminal appeal is pending. Criminal appeal is pending. Therefore, he seeks indulgence of this court. Indulgence of this court. The Mr. Maharana permits that since the appeal has been pending since 2019, it ought to have been disposed of expediently. But for the pendency of the appeal, his right to get license for running the ultrasound clinics is being infringed. Hence, he seeks the direction to the appellate court, namely second edition session judge, for expediency disposal of the appeal. Regard being head to the aforementioned, I am inclined to allow the present petition. Accordingly, so and so is directed to do well to see that the appeal is decided on its merit as expeditiously as possible, preferably within a period of 6 months, with a period of 6 months. Yes. 139. Allowed, na? 139, yes.
May I please, Your Lordship? And I have challenged the order of convenience, Your Lordship, that is 5/9/2017, page 35.
Yes.
My Lord, the petitioner is an advocate of Nimapada Bar. But Your Lordship may kindly see what is the allegation against him, page 10.
Yes.
This is the omnibus allegation that the petitioner and some persons, by that time he was also the president of BJP of Nimapada area.
Yes.
And the allegation is, my Lord, the petitioner and some persons went to the person who
Who is
the,
appearing for opposite party number 2?
no, it is a fresh.
I'll issue notice, and simply issue notice. After 1 week, you file requisite by tomorrow, and yeah. So 130 you have.
I have filed one IA, Your Lordship. I am filed one IA.
Notice on IA. 1 week after I will decide it.
Further proceeding be stayed for that petition.
So item number 147, but it was specifically adjourned today.
I think I'll till 4:30 I'll see how much I can deal.
But it will take some time. But what I want that I was talking with Mr. Barana. He is appearing for the Vigilance. It will be taken up after vacation. And it will show it as part. So that it can be taken up comfortably because it will take some time.
It's a matter.
It's
a matter. The Lordship may keep it what I want that.
Challenged by minor and failed. The ground that this judgment is not applicable for Vigilance cases.
But this is in the weekly list. Let it be there in the weekly list. It will come after vacation only. Because I am aiming at finishing up all the bail matters.
It's not bail.
No. So therefore, it is today. All the bail matters are all bail matters. 1 hearing is complete.
For vacation matter.
So therefore, before vacation, it may not be possible.
No, what I suggest, my Lord. 4 तारीख दिन टिके रखिदेला 15 मिनट खंडे सुनिके पाठ रखिदेले I think my learned senior will not take much time. Mu 10-15 मिनट नेबी आउ notes दे देबे अपन जहा करिए let it be let a law be decided.
There are 40 judgment reserve I have.
छुट्टी रे आउ आड़े ही जो I want your lordship
I just forget thereafter. That's the problem. 40
अच्छा हेला आउ थरे पर आसीओ
let it come up.
In the model in both the cases.
41.
Yes.
There are 3 appeals which are clubbed together. My appeal, your lordship, and your lordship may close it. Because I have twice argued that matter and you submitted my written notes. So that matter may be closed.
What about the other?
My Lord, I am appearing for the amnesty query, but the paper book not ready for not supply me. After vacation.
Arising out of the same. I have already heard judgment is reserved in it.
But I will.
Judgment is not reserved, but I am substantially heard. His part is over.
Yes, my Lord. For our part, my Lord, that will take after vacation, my Lord.
There are three appeals tagged together.
Alibi or something.
Yes, my Lord.
Lordships are correct.
I am for
yes, my Lord.
My Lord, I am for CLC 13 of 2011 and 18 of 2011. Paper book not provide me. Your Lordship directed to the paper.
I have been telling you no paper book business. Take from pen drive.
Yes. Today I will take up. Today I will take up, my Lord. After vacation, my Lord.
No. On 4th.
On fourth. Okay.
You argue it.
Yes, yes, ma'am.
Because I have, then that his hearing is gone waste unnecessarily.
Yeah, all right.
I have twice argued the matter.
Twice argued.
Different
Yes.
matter.
You assist me so that all the three appeal can be.
All right.
139, your lordship.
Common order I can.
Yes, yes.
139, may I?
Can it be on 7th instead of 4th?
Fourth.
My lords,
139.
can it be on 7th instead of 4th, my lords?
Okay, 7th.
Great.
Mr. Das,
139.
Mr. Das, let it be 7th because he is 7th.
7th.
And it's made clear that no further adjournment will be.
Yes,
One.
He's,
Your lordship, lordship will fix it at 2 p.m. That will solve the issue because end of the day, some.
7th is a weekly list, my lord. It will be there on the list only, my lords.
It will be
It can be
there.
taken.
no, no, 2 o'clock. Why he's saying is at least the attention is paid.
As your lordship pleases.
2 o'clock.
As your lordship
139, may I pray? No coercive action shall be taken against the petitioner. It is advocate concern. And
What are the allegations?
Advocate means no allegation. In fact, he is no way involved because he was the BJP president.
What are the allegations?
Allegation 307 and other offences, allied offences.
then
And there is no injury. There is no injury. I have burned that. There is no injury at all. No coercive action.
File process, I'll take it up.
No. What will happen, my lord? If
You are
it
the lawyer, you are supposed to file anticipatory bail. Why you not?
He has already filed anticipatory.
Rejected, I know.
that I have disclosed. That I have disclosed, your lordship. So no.
1 week. See,
No, no.
I'm telling you, it will be taken up on 5th or 6th. Because he's a lawyer, I'll take it up in
Till then, no coercive action. Then your life lordship will not be satisfied. Then no coercive
you know how to avoid. You are lawyer.
My lord.
6th or 7th for you, but process fee you file tomorrow only.
Well, I will file the
I'll see that the entire dispute is settled.
Yes.
No objection from the opposite side.
CRM.
One. Compromise.
They are
appearing. That lady is appearing. No? That lady is appearing in which matter? She's been waiting. Huh?
151 serial 1973-2023.
That is my matter. Your lordship, remember last occasion, your lordship referred the matter to mediation of Balasore. I don't know whether the mediation report has come or not.
Item number?
151. I am for the petition now.
Yes, yes. 1 minute, 1 minute. That lady is waiting. I have seen her waiting.
Your lordship referred the matter to mediation at Balasore. Mediation took place on 17.
Black Sea. 1 minute.
So I would have
Mediation successful? No.
So far as my clients are concerned, my lord, they are willing to have a compromise and they are willing to all terms and conditions.
In the mediation then?
The report, we don't know, my lord, what is the report? Your lordship may peruse that report and take it up on some other date depending on your lordship convenience.
Sir, ମୋର ଗୋଟେ ରିକ୍ୱେଷ୍ଟ ଅଛି।
Yes, madam.
ମୋର ଯୋଉ ଲୟର ଅଛନ୍ତି ଅମର ବଲ୍ଲଭ ନନ୍ଦ, ମୁଁ ତାଙ୍କୁ ଚେଞ୍ଜ କରିବାକୁ ଚାହୁଁଛି।
ଆପଣ କରନ୍ତୁ, କିଛି ଅସୁବିଧା ନାହିଁ।
ସାର୍ ସେ ହ୍ୟୁଜ୍ ମନି ମାଗୁଛନ୍ତି 45,000।
ତା ପାଇଁ ତ କୋର୍ଟ କିଛି କରିପାରିବ
ନା ସେ ସାର୍ କନସେଣ୍ଟ ଲେଟର ବି ଦଉନାହାନ୍ତି। ମୁଁ ସେଥିପାଇଁ ଆପଣ ଏଲାଉ କଲେ ମୁଁ ଆଉ ଜଣେ ଲୟର
କୋର୍ଟ କିଛି କରିପାରିବନି। ଆପଣ ଯଦି ଚାହିଁବେ, ଆପଣଙ୍କୁ ଦରକାର କୋଉ ବୋଲେ ମୁଁ ରିକ୍ୱେଷ୍ଟ କରିବି ଲିଗାଲ ଏଡ୍ କୁ ଆପଣଙ୍କୁ ଏଙ୍ଗେଜ କରିବା ପାଇଁ।
ମୋର ମାନେ ମୁଁ ଜଣଙ୍କ ସହିତ କଣ୍ଟାକ୍ଟ ବି କରିଛି ଅନଲାଇନରେ। ମୁଁ ତାଙ୍କୁ ଦେଇପାରିବି କି?
ଦେଇପାରିବେ ଆପଣ ଇଚ୍ଛା ଯାହାକୁ ଦେଇପାରିବେ କିଛି ଅସୁବିଧା।
କିନ୍ତୁ ସେ କନସେଣ୍ଟ ଲେଟର ଦଉନାହାନ୍ତି କି ମୋ ଫାଇଲ ବି ଦଉନାହାନ୍ତି।
ଆପଣ ଗୋଟେ ଆପ୍ଲିକେସନ ଲଗେଇବେ, କନସେଣ୍ଟ ଲେଟର ଦଉନାହାନ୍ତି, ଏକ୍ସେପ୍ଟ ମାଇ वकालतनामा କରି ଲଗେଇବେ, କିଛି ଅସୁବିଧା ନାହିଁ। ଜରୁରୀ ଆପଣ ଯଦି ଦେବାକୁ ଚାହୁଁଛନ୍ତି ଦିଅନ୍ତୁ, କିଛି ଅସୁବିଧା। ଆପଣ ଯଦି କୌଣସି ଆଡଭୋକେଟ ଦରକାର କହିଲେ ମୁଁ ରିକ୍ୱେଷ୍ଟ କରିବି।
ନାଇଁ, ମୁଁ ଜଣଙ୍କ ସହିତ ଅନଲାଇନରେ ମୁଁ ରହେ, ଅହମ୍ମଦାବାଦରେ ରହେ। ମୁଁ ଆସିଥିଲି ଏଇ କେସ୍ ନେଇକି ମୁଁ ଆସିଥିଲି, ତ ମୁଁ ତାଙ୍କ ସହିତ ଅନଲାଇନରେ କଣ୍ଟାକ୍ଟ କରିଛି। ଯଦି ହବ ମୁଁ ତାଙ୍କ ସହିତ 2 days ଭିତରେ ମୁଁ ତାଙ୍କୁ ମାନେ ଇଏ କରିଦେବି।
Date may be given, my lord.
ଗୋଟେ ମିନିଟ, ମୁଁ ଗୋଟେ ଡେଟ୍ ଆପଣଙ୍କୁ ଦେବି, ଆପଣ ଲୟର କହିଦେବି।
ମୁଁ ଜାଣିନି ଲ
What is the outcome? Unsuccessful. mediation unsuccessful, so therefore it has to be heard. Okay. The mediation cell go to Baleshwar. The District Mediation Center, Baleshwar, has filed a report dated 17/9/2024 inter alia informing this court that the efforts of mediation was unsuccessful. Mr. Sarma, learned counsel for the petitioner, submits that the matter may be heard on merit. आपको ना कौन?
Monalisa Sahu.
Monalisa Sahu, the opposite party.
हाँ, opposite.
Opposite party number 2. Opposite party number 2 submits that he wants to change her lawyer who want to get new lawyers for the purpose of arguing this matter and see if 1 week and then leaves the matter. Would it fix the issue? Entry wanted to continue. 149.
Entry mode to continue.
Entry mode to continue. Yes. 149. Where are they?
Both sides can answer for only giving time opportunity for people who have present, not present. Or present, who will have already been passed. And you also just have a class with the other thing and dispose of it.
Dismiss it.
Dispose of it.
And the last time you didn't come. In the interest of justice, I have adjourned it.
Last time I said, the assistant
Nobody was there.
said, assistants, I was not present in the station. I will also have a.
No, it needs tomorrow roll over. It will be rolled over. Yes. Yes.
My lord,
Any matter which is very urgent to be heard today only?
No.
Rolled over tomorrow. Rolled over tomorrow.
Well,
Yes.
that matter 138, your lordship has directed for 6 months. Can I pray for end of December, my lord? Because the clinic appeal of 2023 LCR has come for.
Yeah?
End of December.
I don't know what is the stage.
LCR has come for. Your lordship may say end of December because the same court.
End of December is 3 months.
Yes, that's. If your lordship may.
End of January.
Madam, 155, my lord. Lordship may keep it to day after, my lord. It is posted today, specifically posted today. Let it be day after tomorrow. Tomorrow, some difficulty. Mr. Palit is appearing. Some difficulty is there.
Who is appearing? You are appearing.
No, Mr. Palit is appearing that.
Acha, Palit.
That Supreme Court order after
Entry order ଅଛି.
Let it be after.
ଛୁଟି ପରେ ଆସୁ ଏଟା ବଡ ହିୟରିଂ ଚାଲିବ.
The counter they have to file. The counter is
counter
not
file
expired.
କିନ୍ତୁ
What is what?
That matter, my lord. that
kindly
Supreme Court-
recollect that matter that was
13 days.
that was the Rashmi Metallic and Cement. Dita company na ହେଇଛି case that is relating to that mining matter. Let it come after interim order is there.
This is what for
Requesting of the cognizance after 12 years, 13 years.
why time?
Then day after tomorrow.
Day after
Let
tomorrow.
it be there. You have 2023 cognizance order stage operating.
Last occasion, your lordship carried about that after the Supreme Court order, 13 days thereafter they have filed the cognizance. What was the occasion why they have filed?
No, that is not
That-
correct.
that
I have
was the-
correct.
We'll see. All other matter will roll over. Tick.